list, fresh admission item number 1.
May it please your lordships. My lords, the petitioner before your lordships is a charitable organization which has a school for mentally handicapped children. Lordship will kindly see, by the Annexure 2, it has been granted by the Society Registration Act, the certificate. And your lordship will kindly see Annexure 3 at page 25. Directed for welfare of persons with disabilities. That has all. This certificate has also been granted by the under the persons.
Mr. Padi there? Who's there for the Union of India?
Union of India. Mr. Padi is appearing. I have solved a copy.
They only give one line like this.
No other. Yes. No. As per it totally, they have to assign the reason. Annexure 1 at page 23, my lords. They have to assign the reasons. The statutory under section 16(4). They have to assign the reason.
No, but you served an advance copy, Mr.
Yes,
Padi?
yes, I have given, my lords.
See, we cannot stay a refusal.
No, that application I have just made only for the purpose of expediting. Because, my lord, there are more than 240 students and they are all mentally handicapped. And we have given, lordship will have just have a glance to the photographs I have.
No, that's okay. That's I don't need to go into that. Where is, there's no one there? Surprising.
Extra copy I can serve, my lords. Lordship may fix any date in the month of August.
You say notice, Mr. P.K. Padi, accepts notice. There he is. Yes. You're accepting notice?
My lord, on behalf of Learned Asia, my lord.
Yeah. So we're issuing notice, you accept notice. How is this a one-line order? Have you seen the paper book?
No, my lord.
All right. It's a one-line order.
My lord.
Reply be filed within 2 weeks, rejoinder for the next date.
Obligement.
Both in the main petition and in the application for interim leave. List on 11th August.
Right. Much obliged.
Obligement.
Supplementary for orders item number 2.
May I please, your lordship? No, sir, in this case, notice in the delay condonation application has been could not be sought because the sole opposite party has left Rourkela. By the time of occurrence, she was staying there. And with much difficulty, we have ascertained her address now. She's staying in Pune. Yes, we may be permitted to take notice.
What is the offense? What is
There is the wife, the petitioner with the wife, she has strangulated her husband to death.
So what has happened? It's an acquittal.
She has been acquitted. That the reason government has filed this leave to appeal petition.
So let us see what made out a ground or not.
Pardon, Lord?
Let's see if you make out a ground or not. Let's see.
Yes, yes. Here was both husband and wife. Both have
she got acquitted when? In 2004.
Yes, please.
And after 18 years, you want us to reopen this?
Plus, leave to appeal petition has been filed in the year 2006.
And then no responsibility. So you wait for 16 years, don't serve notice.
That is the report.
What is all this?
Because notice could not be served because with the apology, notice could not be served because that lady, she was staying at Rourkela. In the meantime, she has left.
Sir, Rourkela seems like Australia.
No,
no, please. This is all Orissa and you're the state. Don't make it seem as if it's some out of the country or continent.
She has been traced out. No, she's residing in Pune.
What is traced out? She's not an accused. She's been acquitted.
Yes.
So don't use those kind of words. And as a state, if you want to locate somebody, you can easily locate.
No,
there has to be some degree of responsibility.
Yes, I beg.
So you satisfy us. Why we should, after 18 years after acquittal, why we should drag her into this?
No, here was the occurrence took place on 13th February 2001. In the
See,
night.
for 5 years, just see how you progress. 23rd March 2006, you filed this.
My lord,
For 5 years, it doesn't even come up for hearing.
there, that is the power.
I don't know what system this is. And 2011 notices issued, forgotten again. The whole matter is forgotten. Till 2018.
No,
I've been through 2 high courts. Criminal LPs are not dealt with like this, sir.
your loss is correct, Miss. I beg your pardon. Your loss is correct. And in the meantime, we have to ascertain where she is staying.
No. But you first convince us now.
Yes, sir.
What's the reason? What's the ground?
It is based on purely circumstantial evidence. Here was 3 days prior to the death of the deceased, there was a quarrel between both husband and wife. And on the fateful night, both husband and wife, they were staying inside the room. And what happened in the night? That the opposite party accused has strangulated the husband to death and locked the door. Then she went to the police station and informed that yes, he is dead. But otherwise, she has informed otherwise. And then police came and the door was locked from the outside. That was opened and the dead body was found inside the room. And no explanation has been given by the accused. And the accused refused to be medically examined even despite 2 attempts. The first doctor, when he wanted to examine her, she refused to examine. The second doctor, a lady doctor, she wanted to examine her, again she refused.
No, what are the circumstances, sir? One is it's a homicidal death, correct?
It is a homicidal death.
What are the other circumstances? Let's see that.
Because 106 of the evidence is
No, straight away 106 won't come, sir. You just go step by step. First, list out what are the circumstances listed out.
Both husband and wife were sleeping inside the room and none else was there in the house. That was the circumstances.
Let's see the discussion.
Because it is that the IO which PW10, so he has stated, this is paragraph 9, page 11. That Parameswar Kishan has deposed that on 14/2/2001 in course of investigation, he examined the complainant, visited the spot, prepared the spot map under Exhibit 8, and submitted requisition to scientific officer Rourkela to assist in the investigation. And broken bangles were recovered from that, which belongs to the deceased. And his further evidence is that he held inquest over the dead body of the deceased and prepared inquest report in presence of witnesses under Exhibit 7 and dispatched the dead body for PM examination. According to PW10, he seized saffron color gamucha, broken bangles, hair, and one printed bedsheet on production by scientific officer and prepared seizure list under Exhibit 9 in presence of witnesses. His evidence further discloses that he also seized wearing apparels of the accused Sushma Panda on the spot in presence of witnesses and prepared seizure list under Exhibit 10. According to PW10, he arrested the accused Sushma Panda on 14/2/2001 and sent the accused to Rourkela Government Hospital, Rourkela, for examination with requisition for opinion if any injury was available and if she had recent sexual intercourse. His further testimony is that he also seized the wearing apparels of the deceased on production by the escorting constable in presence of the witnesses and prepared seizure list. It is also the evidence of the IO that on 17th February 2001, he seized the station diary and report submitted by the accused lady and prepared the seizure list in presence of witnesses under Exhibit 5. According to PW10, on 20th July 2001, he produced the seized gamucha before the medical officer who conducted postmortem examination of the deceased for his opinion as to whether the death of deceased Krupa Sindhu Panda can be caused by strangulation or compression on the neck by means of the said gamucha. His evidence is that he received opinion, Exhibit 2. His further testimony is that on 7th August 2001, forwarded the exhibits to the director RFSL Bhubaneswar for examination through court. And on 15th September 2001, he submitted compliance report and on completion of investigation, he submitted charge sheet against the accused. Evidence of PW11, Cyril Soren, who has deposed that the accused has written in Exhibit 13/2 that she had locked her husband in the house of quarter number 221 of Calling of Air chained in the night between 13 February 2001 slash 14 February 2001. I have already discussed and pointed out in the foregoing para that this document is of no avail of the prosecution. The London additional PP support of his contention, he relied on a decision reported. Because I'm going to the evidence. Who said that was on the fateful night, both husband and wife were only present in that house. May I know how I supplied the deposition copies to your lordship? All the neighbors close have stated. Yes. Yes, that is, your lordship has already got it. It's a PW1. That is because one witness he has stated that I know the accused standing in the dock prior to 2 to 3 days death of the husband of the accused came to my shop, come residence and told that she has got quarrel with her husband. She also alleged about the said quarrel before my mother. My mother advised the accused that she should go and manage the matter as it was their personal and family matter. So there is a quarrel that has been proved. Then PW2 happens to be the doctor. Your lordship may kindly peruse. I'm reading the relevant paragraph to an answer to the court. The court has put the question: the type of injury you have noted during PM examination, whether they can be possible by self-infliction, and whether the strangulation can be caused by the deceased himself. The answer has been given by the doctor. The injuries which I detected can be possible by self-implication. The nature of strangulation, which I have found in my postmortem, is not possible to be caused by the deceased himself. So that says clearly shows that she has been strangulated. Because then I'm coming to the deposition of PW3. She has stated one Ellen Bagala, doctor. On that day, one Srimati Sushma Panda, the accused petition, opposite party, was brought to me for medical examination on police requisition. The lady refused for medical examination by me and told she can give her consent if any lady doctor examines him. Unless I am reading the deposition of witness, have I supplied or not? No. Because may I be permitted to supply the deposition? Madam, sorry, I'm sorry. Am I permitted to supply the deposition copies? May be called submitted.
2011, you notice is issued.
Yes, ma'am.
For 7 years, you did not do anything. 2018, the Registrar Judicial tells you you have to take fresh steps.
Yes, ma'am.
You do not take any steps.
Plus,
Then matter comes up in 2022, which means after 2011, for 11 years, you don't take steps.
that purpose,
What is the point? I don't understand. You don't have to do anything correctly. 2006, you filed the petition, which is also late, I think. No, 2004. What is the explanation for filing in 2006? What is the delay? There's no limitation for this.
it is really very wife has caused the death. We can consider that aspect. Of course, it is no doubt because of non-service of notice on the condemnation application. The matter is legally that has been kept.
This is all condemnation application.
No, not only condemnation. There are also.
Oh, this is still the condemnation application. What is the explanation condemnation application? Let's see that.
There is no,
all this is after the judgment.
Because opinion.
This kind of explanation that it went from one desk to the other.
In
This case number 32. No, we'll dismiss it on limitations. Sir. Miss case number 32 of 2006 must be no, not 4.
So it is usually placed before the
2006. This is an application to condone the delay of 588 days. So the delay is 588 days. No steps are taken for 11 years. Just look at this.
No.
In a delay application, you don't take steps for 11 years, sir.
No, my lord is correct.
Everything is excusable because it's state.
No.
Everything we have to say there is a murder. So even after 22 years, we should condone the delay. 11 years delay in taking steps is also excusable. Everything is because it's a 302 case. This has to be limits of something somewhere we have to draw the line.
No, because in Raukla, that husband she was staying in Raukla. Meantime, she has left that place.
So you don't take steps for 11 years. You're informed way back in 2011 that she has left. You have not bothered to find out.
No, even because her wherever could not be known.
Sir, whatever not known, for 11 years will someone wait?
No.
11 years you're searching for a person in Orissa.
Substantial period, your hospital.
Please.
But she is staying in Pune, Milos. She is staying in Pune. I have got it now.
All right. We've heard you. Very good. All right.
By the time of judgment, she was 45 years old. Now she has become above 60, 63 or so more. Just imagine.
Right. Obliged.
There's a delay of 588 days in filing the criminal leave petition to appeal. Paragraph. The impugned judgment acquitting the opposite party was passed by the Additional District and Sessions Judge on 13th May 2004. Full stop. The present criminal revision petition was filed on 23rd March 2006. Full stop. The explanation offered in this application is that after receipt of the judgment, it was placed before the Assistant Public Prosecutor on 22/8/2005. That is more than 1 year and 3 months for offering his views. Full stop. This delay of 1 year and 3 months is not explained. Full stop. After receiving an opinion on 25th August 2005, it was sent to the office of the Advocate General only on 3/1/2006, which is again a delay of almost 4 months. This again is not explained. Full stop. Apparently, an endorsement was made by the Advocate General on the file to one Shri P.K. Mohanty for his legal opinion. Full stop. That legal opinion was given on 16th January 2006. Full stop. Ultimately, the petition was filed only on 23rd March 2006. Paragraph. It is clear that there is unexplained delay at every stage, and the delay is all only due to administrative reasons. Paragraph. The Supreme Court has, in a series of judgments, not accepted the above kind of explanation for inordinate delay by the state in filing its appeals and petitions. Then set out case law. Paragraph. In the present case, the court is satisfied that there is no valid explanation for the inordinate delay of 588 days in filing the application for continuation delay. Paragraph. Interestingly, in this very application, the state has been extremely lackadaisical in taking steps. After filing the criminal leave petition on 23rd March 2006, it did not come up for hearing for 5 years thereafter. Full stop. When notice was issued in this application on 22nd April 2011, and a noting was made by the office that the addressee had left the place and shifted to her village. No steps were taken for another 7 years. Then on 11th April 2018, the Registrar Judicial passed an order requiring the state to take steps for issuance of notice. That order was not complied with. Ultimately, 11 years after notice was first issued, when the matter came up on 5th July, one more chance was given to the state to take steps, and the case was adjourned today. Even till today, steps have not been taken. Therefore, for 16 years after filing the petition, even the first step of serving notice on the present application on the opposite party has not been taken by the state. Full stop. Paragraph. For all of the aforementioned reasons, the court is not satisfied that the state has been diligent in pursuing the matter. There is delay at every stage of the proceedings. Full stop. The inordinate, unexplained delay is not condoned. Accordingly, the application is dismissed. Consequently, the criminal LP is dismissed.
Supplementary list item number 3.
My lord, item number 3, this matter has been remanded by the Honorable Supreme Court. I have filed the order under Annexure 1 to IA number 13129. Lordship may kindly Annexure 1.
All right. So we have to see whether there's a power to recall the earlier order.
Yes, my lord.
No.
Whether or authority
And-
of the
My lord, your lordship may first kindly see the provision, that is OA Act, section 38A.
Yes.
My lord, power of review has been provided under this section. Lord, may I read, my lord?
Yes, please.
Any decision made or order passed under this act, whether before or after commencement of the Orissa State Abolition Act 1973, other than a decision or order against which an appeal or revision has been preferred under this act, may, within 1 year from the date of decision or order, as the case may be, and after giving all persons interested an opportunity of being heard, be reviewed by the officer who made the decision or passed the order or his successor in office on the ground that there was been a clerical or arithmetical mistake in course of any proceeding under this act. So, my lord, it must be filed within a year. 1, and 2 is, if there is any clerical or arithmetical mistake in the course of any proceeding under this act. This is the crux of this section. My lord, in this case,
Yes.
Annexure 2 was initially passed. My lord, read petition, Annexure 2, page 24.
Yes.
It was passed by the then member Board of Revenue.
Yes.
Thereafter, after 2 years, without assigning any reason or without filing any petition for condonation of delay, the matter was taken up and order was passed under Annexure 4. In recalling the entire order,
Where is that?
that is Annexure 4.
Annexure 4 at page 35.
Yes. Suo motu.
No, a petition filed by the state. Yes. Petition filed by the state. Even if it is filed by the state, they have to assign the reason why they have filed it after 2 years.
No. Was this passed after hearing you or without?
Yes.
Yes.
That is after.
My lord, assuming it has been passed, and I have raised those points that has not been taken note of, because earlier your lordship may kindly turn to page 33. The order passed by this honorable court. My lord, may I read?
Yes.
The last portion? We accordingly dispose of the writ application directing the member Board of Revenue to decide the question of maintainability first with reference to the aforesaid judgment and pass reason order only when the member Board of Revenue is satisfied that such proceeding is maintainable under law, he may proceed with hearing of the case. It is submitted by Law and Counsel for so and so. So my submission before
No,
you.
so what did he do then after that?
Thereafter, they recalled the entire order which was passed under Annexure 2.
No. By what reasons? Let's read that. 3rd
Yeah.
August 2009, Annexure 4.
Yes. Annexure 4.
How does he deal with this judgment?
They have not, my lord, they have not, there is nothing so far as delay is concerned. Your lordship may kindly turn to paragraph 3. Paragraph 3, yes. Honorable High Court in their orders dated so and so are pleased to order that this court shall first decide the maintainability of this revision petition. In fact, this issue are the uppermost in the mind of this court. Therefore, in the very first interim order dated so and so, this court has sought by way of abandoned caution in its letter number so and so the prior approval of the government required under Rule 4 of the Board of Revenue Rules 1959 for consideration of the recall of the order dated so and so of this court as mentioned above. It was also received in the Revenue and Disaster Management Department number so and so. The issue of maintainability of this petition was heard first on 21st 4, 2008. The further hearing of this case had taken place only after this court had decided that it has the jurisdiction to hear the miscellaneous petition filed for recall of the order. In this context, this court refers to so and so, so and so. What is a power to recall? Inherent power to recall its own order, vesting tribunal or court noticed in Indian Bank of India, so and so, so and so. My lord, thereafter, the power to recall a judgment will not be exercised when the ground for reopening the proceeding or vacating the judgment was available to be pleaded in the original action but was not done, or where a proper remedy in some other proceeding, such by way of appeal or revision, was available but not availed. The right to seek vacation of the judgment may lost by waiver, estoppel, or acquiescence. The opposite party number 1 has filed in this court on so and so an application under section 38B of the Orissa State Abolition Act, referred to so and so, to recognize him as the tenant of the land scheduled in paragraph 1 above, accept the payment of the rent from him, and correct the published ROR of suit in his favor. The OEA RC number so and so was instituted on this application. This court, after hearing the petitioner in that case, that is present OP number 1, and Lawrence Special Counsel for the General Administrative Department, has, among others, held as quoted below. Then my
so
lord,
the maintainability is answered only by reference to the Antule judgment.
Yes,
in
ma'am.
para 4.
yes, but so,
that judgment itself says where there is another remedy available, this should not be exercised.
yes, that is also the law. My lord, my
So against the 2005 order, the state could have filed a writ petition here,
yes,
which they did not.
no,
Instead, they went and filed an application before the member board of revenue asking him to recall.
yes, yes,
So that is what we have to examine, whether the power to recall existed or not.
exist or not,
Ah.
and that too after 2 years without assigning any reason for filing of delay.
Anyway,
petition.
let us hear him. Let us hear him.
My lord, the member board of revenue has also relied upon another decision of Honorable Supreme Court,
Indian Bank.
Budhia Swami versus Gopinath Dev, under the OEA Act, that is reported in 1999 to OLR Supreme Court 151.
Where is that?
That is 1999 to OLR Supreme Court 151.
No, where's the judgment?
The learned court below has also.
Where is which para has the
Para 5. Second page.
No, where in para 5? Sorry.
No, I'm very sorry. I'm just giving.
Mhm.
Third page, your lordship. Third page, top.
No. Where has he referred to? Where has the member board of revenue referred to the judgment?
Yes, that is what I'm saying. I'm showing. Yes, paragraph 3, last line.
Para 3.
Para 3, page 36, last line, 1999 to OLR Supreme Court,
What is the power?
and quoted as below. Para 6. What is power to recall? Inherent power to recall its own order vesting in tribunals or courts was noticed in Indian Bank versus Satyam 5 or so and so, by para 20. This court has held that the courts have inherent power to recall and set aside an order obtained by fraud practiced upon the court when the court is misled by a party, when the court itself commits a mistake which prejudices a party. This court would like to quote as below the ruling of the Honorable Supreme Court A.R. Anthule so and so. In our opinion, the court or tribunal may recall an order earlier made by the proceeding culminated. That is A.R. Anthule's case. And the earlier one is Venudhar Swami case, that is 1999 to so OLR. The power to recall a judgment will not be exercised when the ground for reopening the proceeding or vacating judgment was available to be pleaded in the original action but was not done, or when proper remedies in some other proceedings such as by way of appeal or revision was available but was not availed. The right to seek vacation of a judgment may be. This is A.R. Anthule's.
So you also did not invoke 38A.
No.
What provision did you invoke to file this recall application?
Inherent power of the court on the ground of this relying upon the judgment of this
Budhia.
Gopinath Dev, Budhia Swami versus Gopinath Dev. And also another is Indian Bank versus Sam Fibers India Private Limited. Satyam Fibers India Limited.
That is quoted here itself.
If your lordship will go to the merit of the case, your lordship will find that how the party has played fraud and without any ekpadia, without any tenant's ledger, he has got his name recorded. There is no acknowledgement of his tenancy by the ex-intermediary. Everything, there is no record available. And besides that, it is a land of Bhubaneswar and some valuable property was settled in his name by the order, which was subsequently recalled by the impugned order. And on merit also, if your lordship will go through the order of the Revenue Board of Revenue, impugned order of the Board of Revenue, he has discussed everything under the General Clauses Act. By invoking the inherent power, the court has reviewed its own order, recall its own order on the ground that there was a misleading. The party has misled the court. There was suppression of fact. The entire evidence was before the court. It has been discussed, decided. Ultimately, there is a judgment. Right or wrong, there is a judgment. Yes, but there is a power to review. Section 22 of the General Clauses Act also, Orissa General Clauses, whereby in Orissa Act a power to make or issue notification. Whatever. But then it has been considered by the court and there is a judgment. Judgment may be wrong, but then the question is whether the Board of Revenue has the power to recall. It is not my responsible submission to your lordship. It is not wrong. It is by misleading the court, the party has obtained the. Who misled? The party has misled the court. What is the finding of the Board of Revenue? Kindly come. Yes, that is there. Annexure 4. Also procedural irregularity.
He does not go before the Tahsildar at all.
Nothing. Your Lordship may kindly have page 42, para 13 for a moment. No expadia or tenancy documents were submitted by the ex-intermediary in respect of suit land in favor of anybody. That is why the suit land in both the subsequent revision settlements, 1973 and 88, were recorded in favor of the state of Orissa. I see no reason as to why should an ex-intermediary omit or delete the name of a genuine tenant from the records of tenancy, which were submitted by him under section 5J of so also. May the allegation be that he had deliberately omitted or deleted the name of the regions whatsoever. If that be so, it is clear case of tenancy in dispute. One side, the ex-intermediary has denied the tenancy long back by not submitting favorable document, and the other is claiming it 48 years thereafter. Such a dispute can be resolved only by the civil courts and not by the OA collector cum Tahsildar. He has given liberty to the party to approach the civil. Your Lordship may kindly have a glance. The ex-intermediary has to submit the expadia, and there is a tenant ledger prepared by this Tahsildar. Your name has to be there in that tenant ledger, and in the expadia also the ex-intermediary should acknowledge you as a tenant. Then only under section 5J, the Tahsildar will recognize you as a tenant in respect to. Here, he has filed certain documents. Your Lordship may kindly have a glance, Annexure 1 series. What document he has filed? Some rent receipts issued by the Konika estate, and on the basis of these rent receipts, he directly approached the Board of Revenue and prayed that my name should be settled in respect of this particular piece of land. There was no adjudication by the OA collector. These are the material irregularity, procedural irregularity, and your Lordship knows there are several decisions. Your Lordship has also in Brindavan Sharma case also. If the fraud is found, then it vitiates everything. There is no ekpadia. Had there been any document in your favor that ex-intermediary has acknowledged you as a royal, you have paid rent to the ex-intermediary, and your name finds place in the tenant's ledger, all these contemporaneous documents can at best confer any right on the party, on the royals, to be recorded as in the record of right. That is why the Board of Revenue has held, in absence of these documents, in settlement of 1997, in 2 stages of the settlement, the property already recorded in favor of the state government. It is a government property, huge property in Bhubaneswar, and it is already recorded. The Board of Revenue in the order Annexure 2 has undo everything.
I'm not, my lord. The Lordship is putting some question. I am unable to hear.
What's your response with regard to the revision directly by the Board of Revenue?
My lord, my submission before your Lordship is that your Lordship may kindly turn to Annexure 2. Read then Annexure 2, page 25.
Very first paragraph. Just read the first paragraph.
Yes. Yes, madam. Revision case has been filed, Mr. B.K. Dagara, advocate, on behalf of the petitioner under Section 38B of the Orissa State Abolition Act for a direction to Tahsildar cum OA Collector Bhubaneswar to recognize the petitioner as a Sthitiban tenant and to accept the rent from him.
Just stop here for a minute.
Yes.
Just stop here for a minute. Now come to 38B.
Under the purview of 38B.
Now come to 38B.
Yes.
Does 38B permit this kind of a prayer at all? How can a revision petition with this kind of a prayer? A revision itself is to revise some order.
That is true.
It's not a declaratory suit.
Yes, my lord.
Just read this 38B now.
Yes. The Board of Revenue may, on its own motion or on a report from the collector, call for and examine the record of any proceeding in which any authority subordinate to the Board of Revenue has made any decision or passed an order under this act, not being the decision against which an appeal or has been preferred.
So 1 minute. So
Yes.
where is this decision or order under the act by any subordinate authority here?
There is no,
At the time when you filed this revision petition,
yes.
was there a decision or an order of
No,
a subordinate
no.
authority?
Admittedly, no.
Then
Admittedly,
how
no.
was this maintainable at all?
My lord, my submission is that is whatever is there, I cannot improve it.
Correct,
It is-
correct.
yes.
So if it is lack of jurisdiction, that is what I think is being pointed out,
Yes.
that the Board of Revenue had no jurisdiction to entertain this kind of an application at all.
My lord, that is one part. Second part, my lord, assuming it is illegal, the subsequent action of the Board of Revenue in entertaining the case.
No, that the judgment is very clear. Now turn to this Budhia versus Gopinath.
Yes.
This is a Supreme Court judgment
Yes.
and para 8. Yeah.
Yes. Yes.
Para
No, inherent lack of Yes. It is clear from the, my lord, page 39. Page 39, my lord. Para 8. It is clear from the above subsection that the necessary records for the management of the vested estate in question.
No. We're asking you to read the where Budhia Swain has been quoted
Budhia quoted, my lord.
in page 37.
Paragraph 3.
Yeah, that's right.
Page 36.
Correct.
Yes. The further hearing of this case had taken place only after this court had decided that it has the jurisdiction to hear the miscellaneous petition filed for recall of the orders. In this context, this court refers to the ruling of the Honorable Supreme Court in case of Budhia Swain, so and so, so and so. What is a power to recall? Inherent power to recall its own order vesting in the tribunal or courts was noticed in Indian Bank versus so and so. Reported so and so. This court has held that the court have inherent power to recall or set aside an
This
order.
para 8, this is not a quotation from Antule.
No.
This para 8 is actually from Budhia.
Budhia. It is from Budhia, not Antule.
In this case, my submission before your lordship is that assuming, but in this case, there is a specific section to review its own order.
No. So this not even in Budhia, the court said it just come to you have the judgment in Budhia.
That is, in that case also there was a specific say and court held that this
Not
this
under
is
that.
Yes.
In Budhia also
And
they
under
said
the
this
OE
kind of an
also.
application is not an application
That
under
is the
38A because this is not for correcting an arithmetical error.
Yes.
This is another application about the inherent lack of jurisdiction, which could be entertained even by a tribunal. That's why this para 8 is important. Para 8,
In our view.
the tribunal or a court may recall an order earlier made by it. This is not with reference to any provision of the
Provision
statute.
of act. That is true. My lord, my submission only, I have two submissions.
Yes.
Your lordship may kindly consider it.
Yes.
And I have filed my written note of submission
Yes.
stating therein that 8.1, once I am in possession of a particular land, after the vesting, my name should have been recorded in that. That is also different judgments I have given along with my note of submission. If your lordship accept this, then I have nothing to say, madam. Because once there is an order, wrongly or rightly, there is an order.
No, wrongly or rightly is the problem.
Yes.
Wrongly is the problem.
Rather, the third point is directly applicable when the court itself commits a mistake which prejudice. It is a mistake. There is no jurisdiction on the part of the member board of review to entertain such an application directly from a Royat. 38B cannot be invoked.
5.1.
It is a mistake. Rather, I would say it is a mistake on the part of the member to pass the order under Annexure 2 because there was no authority under the law to entertain an application directly from a Royat under Section 38B, which is a revisional power.
Minor Section 5.1 proviso
Yes.
of State Abolition Act.
5I.
5I proviso. Provided that in case where the collector decides not to set aside any such settlement, lease or transfer, he shall refer the case to the Board of Revenue for
Correct.
continuous.
So the collector can refer.
Yes, collector
Here
can.
you are going directly. See, the point really is if there was an order of a collector or a sub-collector, one can understand.
My lord, collector means here that is the collector under the.
Correct.
Yes,
The OEA
yes.
collector.
That is
OEA
Correct.
collector.
It's the OEA
OEA
collector. But there's no order of an OEA collector here.
My problem was that although I was in possession of the land, it was not recorded in my name.
No, you should have gone to that OEA collector first.
And although approach, no step was taken, so I straight came to the Board of
In
Revenue.
fact, the member Board of Revenue here goes a step further. He says even that OEA collector would not have had jurisdiction.
That he has decided.
Because there's no Ekapadia, there's no tenants ledger.
Ekapadia,
So on
yes.
what basis will that
But-
collector decide?
But it is revealed from Annexure 2, there are records. It is revealed from Annexure 2.
No, for which
Earlier,
then you'll have to go to that OEA
Your
collector.
Lordship, may I once suggest, if with your Lordship's permission, ma'am, I may be allowed to approach the appropriate authority.
All right, but this is by remand from the Supreme Court. If you simply do that, I don't know.
After the matter is already adjudicated for a long,
2-3 rounds,
and
it has gone
Supreme
up and
Court-
down. It
My
may not be
lord,
proper.
Supreme
so
Court,
again
because-
giving liberty to
As
the
because-
party, it will reopen the entire.
No, my
matter
lord,
of
my submission before the Lordship is
Uh,
As
that
it appears from the second judgment, there has been participation of the petitioner.
because the as
Participation on merits
Yeah.
vis-a-vis the claim.
my lord,
There has been
your Lordship
participation of
is
the
not audible at all.
Actually, there has been participation of the petitioner in the
Second,
Second
second
round.
yes.
When he's
Yes.
recalling,
and
you appeared, you
That is-
argued on merits.
yes,
There
I
is
have
no allegation of violation of principle.
no,
of
no,
natural
no. That
not
is
only
not
the
the case.
ground of lack of jurisdiction or recall that was raised before the Board of Revenue, but
Yes,
also
yes,
on merits. There has been a decision
yes. I have.
with the participation of the
But
petitioner.
one more thing, only
Once again, remand.
My
I-
lord,
I have also insisted that since it has been filed after 2 years, so they have to explain it. There is nothing.
If there is a mistake on the part of the court or fraud or some reason for lack of jurisdiction, the court can recall its order even after
But
expiry of 2 years.
it must give
2
some.
years applies to review, not to
Yes,
recall.
2 years applies to review. That is true, my lord. 38
not review, it is a recall petition.
No, recall and review. My lord.
My lord, now, in view of the direction of the Honorable Supreme Court,
We are required
we
to.
are now called upon to take decision on 2 issues, whether it is maintainable or whether the petitioner has got any merit in the case. And these things, now again, giving her liberty to approach the Tahsil,
No
it
question.
will go against the
No,
direction of this.
we're not planning to.
Obliged.
All right. You say,
Only thing I
Yes,
submit, my lord. Your
Yes.
lordship may kindly take note of my written note of submission along with the
Yes.
decision I have cited.
all right. This is a writ petition. Questioning. Challenging an order dated 3rd August 2009,
11.
passed by the Board of Revenue Orissa in OEA Miss Case number 13 of 2007, arising out of OEA RC number 56/2003. Stop by the said order, the Board of Revenue, the member, Board of Revenue, allowed the above application of the state of Orissa and recalled an earlier order dated 28 March 2005, which had been passed by the member of Board of Review, allowing the opposite parties OEA RC number 56 of 2003. Paragraph. Initially, in the present writ petition, this court passed an order on 30th June 2010, where in the operative portion, it was said, open quotation, now by the impugned order, the order dated 28/3/2005 has been recalled, full stop. So there is no cause of action of the petitioner to file this writ petition, which is accordingly dismissed. Stop. The interim order dated 10/9/2009 stands vacated, full stop, unquote. Agreed by the above order, the petitioner here filed specially petition civil two 1175/2010, the Supreme Court of India. Full stop. That SLP came to be disposed of by the Supreme Court on 10th January 2018 by the following order. Take from the annexure to IA 13129 of 2020. Paragraph. Consequent upon the above order, the petitioner filed IA number 13129 of 2020 in this petition. In an order dated 20th April 2021, this court listed out the questions that were required to be answered by counsel for the petitioner. Stop. One was whether the claim of the petitioner that late Sri Ramchandra Sahu, that he was granted Ekapadya by the former king of Kanika state on 31/3/1949, which never saw the light of day before 2/5/2003, should have been relied upon by the learned member Board of Revenue in purported exercise of provincial jurisdiction. Question mark. It is observed, open quotation, his direction to record the name of the petitioner is an apparent and the de facto abuse of an original jurisdiction. Stop and quote. Stop. Counsel, the petitioner was also asked to apprise the court, open quotation, about the proposition of law that any court, quasi-judicial authority, revenue authority has jurisdiction to recall any of its own order, which is later found to be without jurisdiction. Unquote, question mark. Paragraph. On the next day, that is 22nd June 2021, an adjournment was sought on behalf of the petitioners, which was granted at the cost of rupees 5,000. Since the request was not found to be reasonable. Full stop. On 21st March 2022, the present council stated that she would file wakalatnama on behalf of the petitioners and sought an adjournment. Full stop. Paragraph. Today, the court has heard the submissions of Ms. Sujata Jena, learned counsel appearing for the petitioner, and Mr. P.K. Manthi, learned additional government advocate. Paragraph. The facts relevant for the purpose of the present case are that the petitioner approached the Board of Revenue with a revision case number 56 of 2003, filed by him under Section 38 capital B of the Orissa Estates Abolition Act 1951 bracket OEA Act. Praying for a direction to the Tahsildar cum OEA collector, Bhubaneswar, to recognize the petitioner as a Sthitiban tenant in respect of two parcels of land, one Sabik plot number 259 of an extent of AC 0.88 decimal and Sabik plot number 272 of an extent of AC 0.50 decimal, stated to be owned by the ex-ruler of Kanika, Shri Shailendra Narayan Bhanjdev. The claim made by the petitioner in the said application, in the said petition, was that the ex-ruler had inducted him as a tenant on 31st March 1949 and granted patta with a rent of rupees 9 and patkar of 5 annas. It was accordingly claimed that a record had been prepared in favor of the petitioner in the Raj estate. Full stop. The petitioner would claim to be paying rent to the ex-ruler from 1935 to 1952. That is up to the date of vesting of the estate in the state government under the provisions of the OEA Act. Full stop. It was claimed that the tenancy was protected under Section 8, bracket 1 of the OEA Act. Full stop. Therefore, it was claimed that since the petitioner was a tenant under the landlord before the date of vesting, he is deemed to be a tenant after vesting of the land in the state government. Full stop. Paragraph. On that application, the member Board of Revenue called for a field inquiry report from Tahsildar Bhubaneswar. Full stop. In his report, the revenue inspector Kalarahanga informed the Tahsildar by letter dated 8 October 2004 that the petitioner was in possession of the plot numbers 309, bracket part, to an extent of AC 0.500 decibel, and 267, bracket part, to an extent of AC 0.884, and had constructed 2 residential houses by planting certain trees. Full stop. This report, this was forwarded to the Member Board of Revenue by the Tahsildar by a letter dated 31st January 2005. Full stop. Acting on the above report, the aforementioned order dated an order was passed by the Member Board of Revenue on 28th March 2005, negativing the objection of the Counsel for the State that there was no jurisdiction under Section 38B of the OEA Act to entertain the said application. Full stop. Since the fact of on merits, it was found that the petitioner had a single quote strong case on subplot number 259 AC 0.88 and number 272 AC 0.50 corresponding to half lot numbers 267 bracket part and 309 part. And since the fact of possession had been confirmed, it satisfied the legal requirement under Section 8 bracket 1 of the OEA Act. So it was concluded, it was the order ended with the statement, open quotation, it can be safely concluded the tenancy has been created and subsists over the said plots. Full stop, unquote. Paragraph. The state of Orissa filed the aforementioned OEA miscase number 1307, 2007, for recall of the above order dated 28 March 2005. Full stop. When the said application was filed, the petitioner filed a writ petition civil 12817 of 2008 in this court, challenging the initiation of the aforementioned proceedings by the Member Board of Revenue. The grievance made by the petitioner was that despite questioning the maintainability of such an application, the Member Board of Revenue was, open quotation, proceeding with the hearing of the case on merits, unquote. It is accordingly prayed that only after deciding the issue of maintainability should the Member Board of Revenue proceed with hearing the case on merits. Full stop. Paragraph. By an order dated 26th September 2008, this court disposed of the above writ petition, directing the Member Board of Revenue to first decide the question of maintainability, and only after being satisfied about the maintainability to proceed with hearing the case on merits. Paragraph. Thereafter, the impugned order was passed by the Member Board of Revenue on 3rd August 2009. Full stop. On the issue of maintainability, the Member Board of Revenue relied on the decision of the Supreme Court of India in Budhia Swine versus Gopinath Dev, 1999, 2 OLR, bracket SC 151, and concluded that since in the present case, in the earlier order dated 2nd May, by order dated 28 March 2005, the tribunal acted without jurisdiction. It had the power to recall its earlier order. In particular, it was pointed out that the language of Section 38 capital B was clear, that a revisional power could be exercised, open quotation, only against a decision made or an order passed by the subordinate authorities under the provisions of the OEA Act. Full stop, unquote. Since nothing was indicated in the application before the Member Board of Revenue regarding the decision or order of the subordinate authority which was being assailed, it was plain that the Member Board of Revenue had, in entertaining the revision case number 56 of 2003 and passing the order dated 28 March 2005, acted without jurisdiction. Paragraph. As regards the merits of the petitioner's claim, it was found that unless the pre-vested rights of the tenant were incorporated in the record of rights by the Tahsildars on the basis of entries in the revenue records transferred by the ex-intermediaries, soon after the vesting of the estate, it was not open to the OEA collector cum Tahsildar to inquire into and adjudicate on the claims of applicants that they were tenants prior to the vesting of the estate. Full stop. The incorporation of tenants in the above manner was an administrative decision and did not involve any inquiry or adjudication. Full stop. In the present case, there was no record in the form of an ekapadya of the ex-intermediary, nor any intimation regarding maintenance of any tenant's ledger showing the name of the present petitioner as a tenant. Full stop. This was the reason why in the revision settlements of 1973 and 1988, the land in question was recorded in favor of the state of Orissa. Full stop. If in fact the petitioner claimed that his name had been wrongly left out by the ex-intermediary from the tenant's ledger, then the remedy of the petitioner lay in the civil court. Full stop. Section 8(1) of the OEA Act did not provide for entertaining an application for recognizing a person as a deemed tenant under the OEA Act. So therefore, the entire proceedings before the Member Board of Revenue was without jurisdiction. Reference was made to the decision in State of Orissa versus Brindaban Sharma, 1995, Supplementary 3 SCC 249. That if an OEA collector were to conclude that a lease or transfer or settlement was made prior to the vesting of an ex-estate, such OEA collector should obtain prior confirmation from the Board of Revenue under Section 5(1) of the OEA Act. Full stop. This legal position was reiterated in State of Orissa versus Haripriya Bisoi, 2009 2 OGR 54(SC). Full stop. There had been nothing brought on record before the Member Board of Revenue to the effect that such confirmation of the claim tenancy had in fact been granted. Paragraph. For all of the aforementioned reasons, the order dated 28 March 2005, passed by the Member Board of Revenue, was held to be without jurisdiction and was recalled. Paragraph. Ms. Jena submitted that the power, if any, to recall of the Member Board of Revenue to recall an earlier order is traceable only to Section 38 capital A of the OEA Act, which reads as under reproduce 38A. According to her, outside of the above provision, there is no power or jurisdiction in the Member Board of Revenue to entertain an application for recall of its order, particularly more than 1 year after it had been passed, and not limited to correcting clerical or arithmetical mistakes. Full stop. She accordingly submitted that the impugned order was without jurisdiction, as there was no power in the Member Board of Revenue to recall the order. Paragraph. On merits, it was submitted that the documents available with the petitioner were not appreciated by the Member Board of Revenue. Full stop. The report of the Tahsildar was in favor of the petitioner. It showed that he was in possession of the 2 plots in question and had constructed houses and had remained there for many years. Full stop. It is submitted that on merits also, therefore, the Member Board of Revenue erred in recalling the earlier order. Paragraph. Mr. D.K. Monti, learned AG, on the other hand, submitted that the power of a Member Board of Revenue to recall an earlier order, which was vitiated for inherent lack of jurisdiction, has been settled in the decision of the Supreme Court in Budhia Swine versus Gopinath Dev Supra. Full stop. In the present case, since there was no occasion for the Member Board of Revenue in the first instance to have exercised powers under Section 38 capital B of the OEA Act, since there was no order of a subordinate authority which had to be revised, the order dated 28 March 2005 was plainly without jurisdiction. Full stop. This satisfied the tests laid down by the Supreme Court in Budhia Swine versus Gopinath Supra, and therefore there was every justification in the Member Board of Revenue recalling the earlier order. Full stop. On merits, he pointed out that merely being in possession of the land in question was hardly sufficient to recognize the rights of person as a deemed tenant within the meaning of the OEA Act. Full stop. With there being no Ekapadia tenant's ledger and no other similar document produced by the petitioner, the question of recognizing the petitioner as a single court's deemed tenant, unquote, on the date of vesting of the land in the state, even within the meaning of Section 8(1) of the OEA Act, did not arise. Full stop. He pointed out that on merits also, therefore, no case whatsoever was made out by the petitioner for grant of the relief prayed for. Full stop. Paragraph, the above submissions have been considered. Paragraph. On the question of the power of the member of Board of Revenue to recall an earlier order which was vitiated by lack of jurisdiction, the decision of the Supreme Court in Budhia Swine versus Gopinath Dev Supra is instructive. So that was a case that arose under the OEA Act itself. Stop. The specific question in that case also was about the power of the OEA collector to review or recall an earlier order. Full stop. Importantly, just like in the present case, in that case also, an argument was advanced that the only power of review under the OEA Act is Section 38 Cap A. Which had not been invoked in that case. Stop. In para 5, the court noted as under, reproduce para 5 paragraph. Then the Supreme Court proceeded to discuss the purport of a power of recall and observed as under in paras 6 to 8 paragraph. The above discussion makes it clear that the Supreme Court did recognize a power of a tribunal or a court to recall its order, notwithstanding the absence of any specific provision in the statute under which such court functions. Stop. The specific instances where such power of recall could be exercised included the proceedings suffering from, open quotation, inherent lack of jurisdiction, unquote, and where, open quotation, such lack of jurisdiction is patent, full stop, unquote. In the present case, it will be recalled that even in the first instance, the state did object to the exercise of jurisdiction section 38 capital B of the OEA Act by the member Board of Revenue by pointing out that the jurisdictional requirement of that provision was not met in the present case. Full stop. That was, however, brushed aside by the member of Board of Revenue when the initial order dated 28th March 2005 was passed. Paragraph. It is plain that you say section 38 capital B bracket No, section 38 capital B reads as under. Reproduce 1 and 2. Paragraph. A plain reading of section 38B, bracket 1, reveals that the occasion to exercise the revisional power by the Board of Revenue will arise only where there is any open quotation record of proceeding in which any authority subordinate to the Board of Revenue has made any decision or passed an order under this act. ... Unquote. Without there being an order or decision of a subordinate authority under the OEA Act, the occasion for the Board of Revenue to exercise the revisional power simply does not arise. Full stop. This is the basic jurisdictional requirement of section 38 capital B, bracket 1 of the OEA Act. Full stop. This was not met as far as the present case is concerned. Full stop. When the petitioner approached the member Board of Revenue with the petition under section 38 capital B of the OEA Act, there was no order or decision of the subordinate of any subordinate officer authority under the OEA Act. Full stop. The very first paragraph of the order dated 28 March 2005 of the member Board of Revenue reveals that the said revision petition was for a declaration for a direction, to the Tahsildar cum OEA collector, open quotation, to recognize the petitioner as a Sithiban tenant and to accept rent from him, unquote. In other words, it was in kind of a declaratory relief coupled with a mandamus, neither of which is even envisaged as a relief that can be granted under section 38 capital B, bracket 1 of the OEA Act. Full stop. On the face of it, therefore, the entire proceedings stood vitiated by inherent lack of jurisdiction in the member Board of Revenue. Paragraph. The court is therefore satisfied that the tests laid down in section para 8 of the decision of the Supreme Court of India in Budhia Swine versus Gopinath Dev Supra is met in the present case, and that therefore there was justification in the member Board of Revenue entertaining the application filed with the state of Orissa for recall of the above order. Full stop. In other words, the said application was maintainable before the member Board of Revenue. Paragraph. On merits, the petitioner was unable to point out that there was in fact an Ekapadia and a tenant's ledger in the present case that was available with the petitioner and could be produced before the OEA collector. Full stop. The fact of the matter is that there is no such document, even as of today. Full stop. The only material that was available with the Board of Revenue when the petitioner's revision petition was first heard, and which is the only material available today, is the report of the report of the revenue inspector, which is forwarded by the Tahsildar to the Board of Revenue. The petitioner was in possession of the lands in question and had constructed certain buildings and planted trees. Full stop. Certainly, this was not material on the basis of which the petitioner can be expected to be declared to be a single quotes deemed tenant, unquote, under section 8, bracket 1 of the OEA Act. That is a tenant who was that is being a tenant under the ex-intermediary and automatically continuing as such on the date of vesting of the land in question in the state. Full stop. As correctly pointed out by the Board of Revenue in the impugned order dated 3rd August 2009, without there being a tenant's ledger and the Ekapadia and a tenant's ledger provided by the ex-intermediary to the state authorities. The question of an OEA collector or Tahsildar entertaining an application for recognition by a person as a deemed tenant would not even arise. Full stop. It is for this reason that the Board of Revenue has correctly observed that if the petitioner had a grievance about his name being left out from the tenant's ledger, then the only remedy lay in civil courts and not elsewhere. Full stop. Paragraph. Therefore, this court is satisfied that no, you say the other important aspect of the matter is that even after holding proceedings in connection with the prayer of a person to be declared as a single courts deemed tenant, that declaration cannot be granted by an OEA collector without there being confirmation by the Board of Revenue in terms of Section 5 bracket small 1 of the OEA Act, as has been explained by the Supreme Court in the decision in Vrindavan Sharma versus State of Orissa versus Vrindavan Sharma, Supra, and reiterated in State of Orissa versus Haripriya Basar, Supra. Paragraph. With the legal position being absolutely clear, there can be no doubt that in the present case, the petitioners failed to make out any case on merits for being declared to be a deemed tenant, as prayed for by him. For the aforementioned reasons, the court finds no error having been committed by the Board of Revenue in passing the impugned order dated 3rd August 2009, and in recalling the earlier order dated 28th March 2005. Stop. The writ petition is accordingly dismissed. No order to cause.
Supplementary list item number 4.
The secretary to GA department has filed the affidavit.
Task force, field cover.
Flag Y. It is available at flag Y.
Yes. All right. Yes.
Para 18 at page 28.
Wow, 803 allotments in this street. So when we talk of multiple allotments, it means the same plot is allotted to many people, is it?
Multiple allotment.
When we say multiple allotments,
So far as BQ is concerned, we have taken this policy.
no, so vigilance cases, no, I'm on para 7.
Para 7.
So you got 667 files relating to multiple allotment, including 332 from BDA, 257 from CDA, and 78 from OHSB were taken up for inquiry. Of this, 79 cases have been registered. 104 have been returned after inquiry.
Yes, ma'am.
And 401 are pending inquiry.
This is the status which we have indicated.
So 24 criminal cases have been registered. So when we say multiple allotment, meaning what? Multiple, oh, more than one plot. Oh. Ah. So more than one plot, is it?
Yes, multiple allotments. More
For
than
the same person, you allot more than one plot. Must be.
That is the allegation.
Ah.
No, my lord, am I audible?
Yes.
Would your lordships call it a week after? I'll be able to assist your lordships.
Oh, I see. All right.
Little unwell
All right.
today.
All right. All right. At the request of the learned advocate general. List. Should we have it next Thursday or 2 Thursdays?
One Thursday afternoon.
All right. 4th August?
Lordship pleases.
All right. 4th August.
Supplementary list item number 5.
May I please, my lord?
Yes.
This tax appeal is relevant to the assessment year 12-13, my lord.
Yes.
And here the only one issue involved, my lord. The payment to the loan creditors were disallowed under section 40A for non-deduction of tax. And my question of law suggested, my lord, at page 6, my lord, only Roman IV I am suggesting, my lord. Whether the Learned Tribunal has correctly decided the appeal after considering the second proviso of section 40A of the IT Act, that the appellant cannot be treated as an assessee in default under section 201(1) of the IT Act if the recipients have included the receipts paid by the appellant in their respective returns of income and also paid taxes on the same, and there is no liability to deduct tax. And next of 3 series I have enclosed, my lord. Their return and their PL account, everything, my lord. And this case also covered by judgment last occasion also submitted on this. Today also I'm submitting 2 copies.
What do you say?
In this case, the forms 15G was submitted. The clause of 15G form should be that if there is a taxable income, more taxable income, it not be allowed. In all these 3 cases, the tax interest was paid more than that. It is more than 2.5 lakhs. Man, it was taxable amount. In all these 3 cases, if you go for the assessment order, page number 10 of the assessment order, page number 10 of this petition, the payee on verification of ledger copy of unsecured loan, it is found that the following cases, the amount of interest paid or credited to the payee has exceeded the maximum amount which is not chargeable to tax from the interest other than interest on security. On these 3 occasions, they have interest has been charged. In this case, 15G will be invalid. The form will be invalid if that amount exceed taxable limit.
My lord, the second proviso to 40AIA provides that if the payee disclose those incomes in their return, the petitioner cannot be treated as an assessee in default under section 2011.
So his question is not on the 15G part. He is therefore confining it only to question 4.
Number IV.
You say admit the following question is framed for consideration. And reproduce question 4. Should we proceed to decide it?
It may be taken on next date. Siddharth Mahapatra will.
List for final hearing on 7 December.
Name of Siddharth Mahapatra may be taken into account.
Shreyas Mahapatra.
Obliged.
Supplementary list item number 6.
Dear my lords, for the assessment year 10-11, an assessment proceeding was initiated under Annex 3 at page 35. My lords will be pleased to get it. My lords, just during the initiation of the proceeding, the Joint Commission of Income Tax, who has no jurisdiction to transfer a case record from one assessing officer to another assessing officer, transferred the case record from SCIT Rourkela to the ITO Ward B Rourkela. Lords, you will kindly see at page 35. I am just pressing few lines. Thereafter, the jurisdiction of the case was assigned to the undersigned by the JCIT Rourkela Range, Rourkela by order dated 1st October 2012. Well, that annexure is
the
also...
tribunal has remanded it back to the right jurisdiction.
No. Well, Lords, you will kindly see the order of the ITAT I am placing before Lordship. That is page, para 14, page 67. Admittedly, what the tribunal writes like this. Admittedly, under normal circumstances, a consequential assessment order passed by the ITO Ward 2, Rourkela, would be liable to be quashed. However, a perusal of the assessment order shows that a notice under section 143(2) had originally been issued by the SCIT, Rourkela Circle, Rourkela, who had the jurisdiction to do the assessment. The next page. The procedural defect occurred when the JCIT Rourkela Range, Rourkela transferred the file of the assessee from the SCIT Rourkela Circle, Rourkela to the ITO Ward 2 Rourkela. This procedural defect is incurable, and at the point of defect, the proceeding would have to be cut. After saying this, my lords, again he transfers it by referring a decision of this honorable court. I have also got that decision. The reference in that decision is totally different. There, lords will kindly see, the question was there referred was whether the penalty was validly imposed or not. And a passing remark was given by this court. Your lordship will kindly see, at the instance of
the same is to be finalized by the officer having jurisdiction.
Yes. Now, my lords, he says the defect is incurable. If it is incurable, it has to be struck down. You have no jurisdiction.
No, that's right. Once it is struck down, Mr. Rai, the only short question is, once it is struck down,
yes,
is there a power to remand it?
Yes, yes.
The correct officer.
Yes, that is the question, my lords.
Why not? Why can't it be? See, once you find an order is without jurisdiction, therefore you set aside that order.
Yes.
Now that exercise is asked to be performed by the officer having jurisdiction. What is wrong with that?
My lords, the wrong is, my lords, once the SCIT commits a wrong, the JCIT, I'm sorry, my lords, JCIT commits a wrong.
So he's setting aside the whole assessment order because that wrong has been committed. It was sent to this ITO Circle 2.
My lords.
So the entire order is set aside now.
Yes.
So now what should happen next is the question.
The next is, my lords, once you have, my lords, with great respect, my lords, once the tribunal finds, because it's a question of jurisdiction, my lords, if the jurisdiction is absent, my lords, then, my lords, the entire exercise is void.
Correct. And it has been declared void. The order has been set aside.
My lords.
So now what you do after that is a question.
My lords, after that, my lords, it was not proper on the part of the tribunal to set it aside to SCIT, my lords.
Why not?
My lords.
Why not?
My lords.
The authority having jurisdiction should now perform the exercise.
My lords, the SCIT also. My lords, now the SCIT also doesn't function, my lords.
That is different. That's very good news for you.
At least, my lords, now the National Faceless Assessment Center has come, my lords.
Correct.
Now, my lords, it will be initiated by the National Faceless, and had the tribunal says that yes, now the National Faceless.
That is your new jousting partner.
My lords,
the National Faceless Assessment Center.
My lords, at least, lords, what I say, my lords.
Yes.
Only my lords may issue notice.
No, for what? For what? There's no need. We'll just simply not uphold the order. You say the SSC's, this is an appeal when SSC agreed by an order dated 31st May 2022 passed by the Income Tax Appellate Tribunal, Cuttack Bench, bracket ITAT, in ITA number 176/CTK/2016 for the assessment year 10 level. Paragraph. The short ground which is urged for consideration by the SSC is whether, after finding the assessment order passed by the ITO Rourkela 2 Circle to be entirely without jurisdiction, the ITAT was justified in remanding the matter to the Assistant Commissioner of Income Tax, bracket ACIT, who admittedly had jurisdiction, to proceed afresh in the matter. Question mark. Paragraph, the facts are not in dispute. Full stop. a notice was issued by the ACIT Rourkela Circle, Rourkela, who had jurisdiction to conduct the assessment, to the SSC under Section 143 bracket 2 of the Income Tax Act 1961 bracket Act. However, before he could further proceed in the matter, the Joint Commissioner of Income Tax bracket JCIT, Rourkela Range, Rourkela, transferred the file from the ACIT to the ITO Ward 2, Rourkela. This was clearly without jurisdiction, and all actions taken consequent thereto by the ITO Ward 2, Rourkela, was also without jurisdiction. Correctly, therefore, the ITAT set aside the assessment order as it had been vitiated by a single court's incurable defect, unquote. Paragraph. Mr. Siddharth Rai, learned counsel for the appellant, states that in support of its decision to remand the matter to the ACIT for fresh assessment, the ITAT relied on the decision of this court in Shivkumar Agarwal, Commissioner of Income Tax versus Shivkumar Agarwal, 1990 186 ITR 734, in which only a passing remark was made that if the penalty had been imposed by an officer not having jurisdiction, the proceeding by itself does not come to an end, and that, open quotation, the same is to be finalized by the officer having jurisdiction, full stop, unquote. Paragraph. This court is of the view that once the order was set aside for lack of jurisdiction, the consequential direction of the ITAT that the assessment should now be by the officer having jurisdiction cannot be said to be erroneous in law. Full stop. It was a consequential order, and which was only natural because the ACIT, admittedly the officer having jurisdiction, had initiated the proceedings by issuing the notice under Section 143 bracket 2 of the Act. That proceeding had to therefore be taken to its logical conclusion. Paragraph. In that view of the matter, no substantial question of law arises. The appeal is dismissed.
My presence, you can. My
His presence.
Yes, of course.
He has got another 2 matters with me.
All right.
Supplemental list item number 7.
This has been filed by the state.
Mr. Roy creates all the appearances, my lord. Siddharth creates all the appearances.
Yes.
Item 7 on 8/3/2022 and 4/5/2022.
Right.
My lord, directed to serve a copy of the writ petition on the counsel on the opposite party number 1 herself. Even though I have issued 2 letters, but I have not received any instruction regarding service of notice.
No, even about the current status. We wanted to know whether that person is still around and what is she doing and all that.
She's serving in a school, my lord.
Because in 2009, it's 39 years, 13 years. She's 52 now.
By the impugned order, Land Tribunal directed to create a post to adjust the opposite party number 1.
So no, there was no stay, no? That's why we wanted to know the...
No, there is a stay of the order. 2110.
No, but if she's still serving the school, which means she's somehow working.
No, in any other school, she is working probably.
Don't say probably. Is she working, not working, what? That's why we wanted to know the current status. Also, I think you've challenged an order dated 2005.
2007 order.
In 2009.
Yes.
What's the explanation of the delay? No explanation, sir. Say against the order dated 22nd February 2007. The state has come before this court with the present writ petition on 18/3/2009, almost 2 years thereafter. Full stop. There is no explanation in the petition. The delay in filing it. Full stop. Paragraph. It is noticed that while issuing notice in the present petition on 21/10/2009, a stay was granted of the impugned order of the tribunal. Full stop. Thereafter, the matter did not come up for almost 13 years. Full stop. When it came up last for hearing on 8 March 2022, the court had required counsel for the petitioner to obtain instructions on the current status of opposite party number 1. Full stop. On the next date, that is 4th May 2022, the court is informed that it will be served at her present place of residence, present place of service. Full stop. That, however, has not been done till date. Correct? Full stop. The only information available with the petitioner is that opposite party number 1 is still in service. Paragraph. Considering that despite the interim order passed by this court, the opposite party number 1 is still in service, and for more than 14 years has not been able to be served in the present petition, it would not serve the interest of justice to keep the present petition pending by giving more and more opportunities to the state to do so. Full stop. Leaving the questions of law arising from the impugned order open, the court expresses its disinclination to interfere and disposes of the petition. The interim order is vacated.
Supplementary list item number 8.
May it please your lordship. Your lordship, the award of the Labour Court in the matter of an alleged refusal of employment to a watchman of a ladies' hostel, that is of the Utkal University, is under challenge here, your lordship. Your lordship, on the last occasion, I had earlier sought to address your lordships in the matter of that hostel not being an industry. What is without her, your lordship remembers that.
Correct.
Going through the facts of the case and
Yes.
also the materials on record, as also the settled position of law. I don't want to press that application now, that issue now, because the educational institution is already an industry. Your Lordship also is aware of that.
Correct.
However, there are certain frailties in the award, Your Lordship, which I may be permitted to place before Your Lordship.
All right.
Yes. Your Lordship, the background facts of the case are that on 31/1/1998, the opposite party workman was initially temporarily appointed as a watchman in the ladies' hostel of the Utkal University. And on 8/9/2000, Your Lordship, the opposite party was directed to do work of gardener on account of allegation of his bad conduct raised by the hostel inmates, Your Lordship. That is the facts on record, Your Lordship. Then 39/2000, he says that he has been allegedly refused employment by the superintendent. And he has not worked thereafter, Your Lordship. And on 18/10/2000, that is after about 18 days, he scolded the superintendent and the warden of the ladies' hostel in filthy language and gave life threat to them, Your Lordship. Then then the matter was reported to police. The affair was lost, Your Lordship. And on 19/10/2000, he abstained from the duties. And as per his statement before this honorable court, as also in the learned court below, he had worked with the opposite party's residential quarters till 13/2/2002, Your Lordship. And thereafter, he has raised a dispute before DLO Khorda, that is conciliation officer, on the issue that he was allegedly terminated with effect from 39/2000, Your Lordship. With this background, Your Lordship, may kindly turn to page 18, Your Lordship. 18 of the, that is the written statement filed by the management, Your Lordship. That's the petition. Your Lordship.
Yes.
Your Lordship, para 6. Sir. Subpara, Your Lordship. It is to mention here that basing on the allegation of the inmates of the Chhatri Nivas and their guardians against the workmen, the administrator was complained to change the employment of the workman from watchman to gardener, and to that respect passed an order bearing number so and so dated 8. Then Your Lordship may come to the next page, para 11, Your Lordship. That, Your Lordship, let's say page 19, Your Lordship. That although the workman was cautioned to amend his behavior. I'm sorry. Behavior in respect of behavior towards authority, it was yielded no result. And on 18/10/2000, at about 9:30 a.m., the workman directly abused the management, superintendent, and warden of the hostel in filthy language and have threatened to do away with their lives. For such overt action of the workmen, the matter was reported to the Sahidnagar police station through office letter number so and so, dated 23/10/2000, after getting due permission from the university authority on being informed about such nuisance. Then, Your Lordship, this the next page, Your Lordship, page 20, these submissions have been made which are in the written statement. Your Lordship. Now, Your Lordship, may come to the evidence which was laid by the workman, Your Lordship, page 21. Your Lordship. Your Lordship, let's see, page 21.
Yes.
Now, Your Lordship, he says that it is his evidence, because surprisingly, the evidence affidavit, the first portion is cut, Your Lordship. I don't know why. But he says on para 6, on 5, that on 39/2000, management verbally refused my employment without any notice or assigning any reason. Then 6, on 1/10/2000, I met the hostel superintendent of the hostel and requested him to allow me to discharge my duty, but that was in vain. But he assured me to give extension of my service, and later, if I will work at his residence inside the Banibihar campus instead of working at Chhatri Nivas. That according to the verbal instruction of the hostel superintendent Ramadevi Chhatri Nivas, I worked at the residence of superintendent, but the superintendent always assured me to disburse regular salary, but no salary was disbursed to me. Then I worked till 12/2/2002. You also may kindly note this date. 12/2/2002 at the residential quarter of the hostel superintendent without salary, with the hope that the superintendent will regularize my service and will disburse my arrear salaries. That as no salary was paid and superintendent showed indifferent attitude being compelled, I approached the district labor officer and I gave a petition to him. And after several inquiries, then your lordship, the reference was made, your lordship. Then your lordship, in the case 23, your lordship, in the cross-examination by the management, he has said that I have not worked under the management after 39/2000. So that is admitted by him because Chhatrinivas, he has never worked after 39/2000, your lordship. Then, your lordship, he also denies that it is not a fact that I was transferred and I did not receive the transfer order. Your lordship may now come to the management's evidence, which is at page 25. Sorry.
Yes.
The second party was watchman at Ramadevi Chhatravilas who indulged in objectionable, notorious activities in the ladies' hostel. He was cautioned to refrain himself of such activities as alleged by the inmates of the hostel regarding his bad conduct. The first party transferred from the duty of the watchman to work as gardener. The office order number so-and-so issued by the first party delivered to him on 18/10/2000 around 9:30 a.m. Sri Chankadhar Digal, the second party being irritated, came to the hostel with his wife at 9:30 a.m., scolded the superintendent warden in filthy language and threatened to do away with their hive, that is Shalanko Honeybee, that means to axe the both of them. Due to such crime committed by the second party, the then superintendent lodged a FIR in the Saidnagar PS against Chankadhar Digal for the life security and sanctity of the ladies' hostel. This FIR was communicated in letter number so-and-so. Then you will not see this particular aspect, I don't think it has been ever rebutted by the workmen in the cross-examination, your lordship, whatever has been said about him. So in the second page, your lordship, the page 28 in the cross-examination, of course, the question was asked, the originals of Exhibit A to C are with the management and the workman abandoned the service, which means voluntarily left the service. Though in my affidavit evidence, I have mentioned that Exhibit A was delivered to the workman, but actually he refused to receive the same and it was not delivered to him. It is not a fact that the workman never refused to receive Exhibit A. Then, your lordship, on this, your lordship, this evidence, the award has been passed and your lordship may come to with regard to this continuous engagement, your lordship, I want to point out to before your lordship a particular statement which is given in the counter of the opposite party, your lordship. Page page 47, your lordship. Page 47, para 14, your lordship. Is the pagination correct, my lord? 47, para 14 of the counter. Page para 14 of the counter, your lordship.
Yes.
Para this sub-para, your lordship. So far as entrustment of work other than the work assigned to the post of watchman is concerned, it is humbly submitted that after disengagement illegally, this deponent, being a poor laborer, had approached the then superintendent for sympathy. Taking advantage of his situation, he was exploited by the superintendent for a considerable long period, which this deponent had narrated in his petition filed before the learned court below. From the above, it cannot be held that this deponent was offered with an alternative job by the management. The documents filed by the management to prove this petitioner was offered with alternative employment were fabricated for the person. Here, your lordship, there are two aspects. One is the job offered to him was a gardener, which was in September 2000. And what he says here about the superintendent being serving the superintendent, that is in the personal residence, your lordship.
So what the labor code seems to hold
yes.
is that if one accepts your plea that you did not terminate his services, he abandoned it. That is your plea.
No. That is exactly what I am going to point out, your lordship. Your lordship comes to the finding, your lordship, page 33, your lordship.
No. Is it not your case that he voluntarily left the service?
He left the services. That is exactly. Yes.
No. So the tribunal seems to suggest,
yes,
it's observing that if he had voluntarily left the service, then how come you did not hold any inquiry about his absence?
I should have proved it before the tribunal, Your Lordship. That is the labor court has posed me that question. That is true.
Yeah. Yes.
And that is admittedly that has not been done, Your Lordship.
Correct.
I concede. That has not been done, Your Lordship. And Your Lordship, this case says that Your Lordship may come to page 33. That is finding.
Yes.
Because with regard to the industry and the workman, Your Lordship, that issue was raised before him. And he says, giving citation to that 78 Supreme Court, Bangalore Water Supplies case, Your Lordship. And he says...
So he has not come back to service, correct? Because of the stay.
No, he is continuing to get the 17B wages, Your Lordship.
No, that's right. Yes. He's only getting 17B.
Yes.
No, and what is his age now?
47. 48, Your Lordship.
Yes. May I please, Your Lordship, that the...
Let me complete. Mr. Rathal, let me complete.
Yes.
Let me complete. Your Lordship, this page 33, Your Lordship, he defines what is given industry's definition as given by the 78 Supreme Court, Your Lordship. Then he says that in this instant case, Your Lordship, page 34, until now page 6 of the award, Your Lordship. In the instant case, it is an admitted fact that the workman was serving the management under the management as a watchman. According to the workman, his service was terminated without following the provisions of Section 25F of IDA and without following principles of natural justice. Management has taken the plea that workman is not entitled to get any relief in this case. However, basing on the materials available in the case record and in view of the above authority, on careful consideration of the case, I came to the finding that the establishment of the management is an industry and the reference is maintainable. So this is an abrupt conclusion he has come, Your Lordship. That I wanted to just point out, because of course I'm not going to that aspect of the. I'm not going to other part. I'm going to the merits part only. Yes, the merits, Your Lordship. This para 9, Your Lordship, same page 34. It has been argued by the advocate for the workman that the workman has completed 240 days in service preceding so on. So the management in his affidavit evidence has stated that when the police interrogated the workman by coming to the police station, the workman thereafter never joined his duty from 1910-2000. Your Lordship may note this date, Your Lordship. That was the case of the management, Your Lordship. But that evidence has not been substantiated with other corroborating evidence. That is the finding, Your Lordship. And he says that
no inquiry has been conducted.
No inquiry. I must fairly consider that no inquiry has been conducted. Then, Your Lordship, para 10, after he has discussed many case laws, Your Lordship, starting in page 36, Your Lordship, 2001 LLR, page 54, 1993 LLR 876, 2010 4 LLJ 795, then 2011 LLR 312, and then last 2000 LLR 425. All these case laws he has only narrated, and thereafter, Your Lordship, comes to page 37. So on careful consideration of all the materials available in the case record, as discussed above and in view of the above authorities, I came to the finding that the action of management in terminating the service of the workman with effect from 39-2000 is neither legal nor justified, and the workman is entitled to be reinstated in service. This is the abrupt finding, Your Lordship. My Lord. It's a little not audible, Your Lordship. It is not audible, Your Lordship.
No. Yeah. He relies on a case law.
Yes.
That to say that abandonment of workmen amounted to retrenchment.
Yes, sir. That is case laws, Your Lordship. Yes. There is no dispute about the case laws, Your Lordship. My Lordship. But my humble contention is that if the once a case law, because the facts are there for the court below to consider, Your Lordship, to arrive at the particular finding. One should not travel to the case law to arrive at the finding, Your Lordship. And that is, Your Lordship, will find that because any judgment, Your Lordship also is aware of the principle that it cannot be held as a Euclid's theorem, Your Lordship. Because a single deviation or circumstantial flexibility will also differentiate two sets of cases, Your Lordship. That is there, Your Lordship, 2008 AR Supreme Court, 7788, Your Lordship, and then another is also 7810, Your Lordship. These are all AR SCW cases, Your Lordship, reported. But here, my lords, what I may point out, your lordship, this award and this has come to the abrupt finding that he has been terminated from with 39/2000, and therefore the workman is entitled to be reinstated in service. Even though a matter has been pointed out and an issue has been there that he has left employment from 1910-2000. That is after the incident which happened in assault, in threatening the warden and the superintendent of the hostel. And your lordship knows that this is an educational institution and also a ladies' hostel, your lordship. Such type of behavior cannot be also tolerated there. About whatever the legal procedures, that has not been adopted. I concede, your lordship. But still then, your lordship, when the court will grant the reinstatement, this has to be borne in mind also. That is my humble submission. And your lordship, he has after that, he has only said that he has not gainfully employment elsewhere, so payment of back wages is not justified. So he is granting only 40,000 in lieu of back wages, your lordship. That means reinstatement and back wages of 40,000. So may I humbly pray, your lordship, keeping due regard, my lords, keeping due regard to because his termination, as he says, it is of 2000. Now 22 years have passed by, your lordship. And he has already received the 17B wages also, and there is some other person who is also working. There is no deviation there, and he is also working there. So in my humble prayer, your lordship, that in keeping in view a similar case in 2019 Supreme Court, and your lordship also finds that in the recent times, the objective of the Honorable Apex Court and also this Honorable Court, including your good self, your lordship, that the reinstatement should not stand as a corrective measure in all the cases, your lordship. That is to be also taken care of by...
No, but if you're willing to enhance the amount of compensation, then we can put it to him, then you...
That is exactly I am pointing out before you. That is, so 2019...
No, so what, if you make a reasonable offer, you can put it to him. If you want to enhance the compensation.
Well, because he has already, by now, he has already received 1,50,000 already, your lordship. But I will pay instead of that 40,000. Let it be 1 lakh, your lordship.
Right, I think that's reasonable.
No, my lord, kindly hear me and then...
Yeah, all right.
Kindly hear me, my
Yes.
Initially, the petitioner was appointed in the year 1998.
Yes.
As on consolidated basis as a watchman.
Right.
And he was given posting and deployed in the Chhatri Nivas.
Right.
Deployment is not my mistake, that whether I was deployed in Chhatri Nivas or any other establishment of the university. Thereafter, when I was working in the establishment of Chhatri Nivas, I was disengaged verbally. And another person in my place was engaged. When I requested, then I was asked by the then superintendent to come to my residence. I worked, admittedly, I worked some days in the residence of that superintendent, but not till 2002. My lord, when I was refused employment, I raised this industrial dispute. Initially, an objection was raised that I have never worked 240 days in one calendar year. And I could not also succeed in establishing that fact. And in the first instance, I lost that dispute. And I approached this Honorable Court in one writ petition 2008. In that, during pendency of that writ petition, I obtained certain informations by exercising my right under RTI Act. And the information was supplied by the PIO of the Utkal University, that my attendance register, acquittance register, all these things. And then the matter of, when I mentioned before this Honorable Court, the matter was remitted back for the hearing on afresh hearing. And again, the second round litigation comments. And there the objection was raised with certain fabricated facts that my conduct was bad. And one allegation was alleged before the Sahidnagar police, which were all fabricated. That one alternative arrangement has been made and I was being offered with an alternative employment. My lord, may kindly come to their cross-examination. My lord, kindly come to the cross-examination of the management witness. At page 27 of that writ petition. Page 28 is the relevant, my lord.
Yes.
My lord, the original Exhibit A, the document which was marked as Exhibit A is the appointment, which is the order which my learned senior has pointed out that I was given alternate appointment. But it is clearly admitted that that order was never served to me. Then, my lord, subsequently, I cannot say then subsequently, again, another question was raised that any reminder was issued, because earlier you said that it could not be solved. I cannot say if any reminder was issued to the workman, because this particular document was fabricated. Then, my lord, I'm coming to my conduct part. So, alternate arrangement, which was subsequently the plea was developed by the management at the second round litigation, that I was offered with an alternate employment is absolutely false. No arrangement or no offer was made at that point of time. Then, my lord, so far as allegations regarding my conduct, kindly come to the last paragraph of that cross-examination. Exhibit B, it cannot be said that it was registered as FIR. Now, my learning senior said that it is an FIR.
Yes.
Then, my lord, kindly come to the last paragraph, page 28.
Yes.
That Exhibit B is the alleged affair. What they said that one affair was lost with the Saidnagar PS. But in cross-examination admitted that that was never solved. And it was also inquired by me also. It is not a fact that I accepted the no such document was, no such complaint was ever raised. When the second round litigation initiated, these type of fabrications have been made. And again, the case was, when the writ petition filed, again the case was developed. Because there the plea was taken, there the educational institutions are not covered in Industrial Disputes Act, but here the plea was developed that Ramadevi Chhatri Nivas is not the part and parcel of Utkal University, therefore the case is, the award is wrong. So gradually the management is developing its case. So in fact, the allegations that my conduct is bad, it never proved. Rather, it was found that it was no such complaint was ever lodged before with the police. And the alternate arrangement which was submitted, that I was given alternate employment, is absolutely false. No such offer was ever been given to me. And when there was a specific question that if my conduct was bad and if I lost complaint, that have you initiated any proceeding? No such document except this letter, no such document is available. That is the cross-examination. The management, my conduct was bad, but the superintendent asked me to work in his residence. My conduct was bad. I didn't accept I abandoned my service. What is the allegation? But no inquiry has been initiated against me. No document, it is clearly stated, it is that no other document is available. Only these two letters, which were subsequently fabricated by the management, because by that time, my juniors have been regularized. And in the year 2000, one of the known person of the superintendent was given employment and I was retrenched. So now the age of that particular workman is 47. And it's a tribal boy who is also with a meager amount, that is the 1,500 or 1,250 or something is getting per month. So therefore he has 13 years service. So therefore, my lord, kindly I may be allowed to and reinstated in my service.
Or
May I be?
yes, yes.
Only one second, Your Lordship, what my land friend said, that it is all fabricated documents. That is why before I started, I had taken your Lordships to page 18 and 19 of the written statement, which was filed from the very beginning in reply to the statement of claims.
Yes.
And I have stated all these facts which are there. He says is fabricated.
No, but if it's a FIR, it's an FIR, right? In cross-examination, you admit that this is not an FIR.
Man, that is all right.
So that's yeah.
But only thing is that with regard to the incident, it is already there. It is not fabricated, and the number is also reflected in the statement of claim. I mean, written statement. And there is no rejoinder filed by the workman to these facts, Your Lordship. That Your Lordship will kindly take note of. And with regard to that enhancement which I offered Your Lordship before Your Lordship, that is, I may take the help of 2019 14 SCC page. This is 353, Your Lordship.
All right. Orders reserved.
All right.
Orders.
Supplementary list item number 9.
Which item 9 till that reply is to be filed by the state government lordship. They have not filed in reply to my allegations. The matter of 2013.
Circular of 2013.
Lordship.
Is it still alive? The issue?
Lordship, it is still alive, Lordship. Because we are working under Gram Panchayat, Lordship, and we are covered under rules which has been given for 2008. And subsequently, by virtue of this circular, they have changed the terms of appointment, Lordship, terms of promotion, and which is under challenge.
Interim order is that only that it will be, it's already been disposed of. There's a question of continuing. I don't know why you continue interim order. That interim order will continue anyway. We have said that all recruitments will be subject to the result of the writ petition. No question of continuing that. That is anyway there. What about reply?
Reply.
Because it's challenging the virus of that rule.
Yes.
You say, despite notice having been issued way back on 11 June 2013, challenging the validity of the amendments to the Orissa Gram Panchayat Rules Act.
Rules. That is rules, recruitment rules.
Yeah, recruitment rules. Orissa village level workers, recruitments and conditions of service, rules. No reply has been filed till date. The last opportunity is granted to file a reply within 8 weeks, rejoined for the next date. Let's stop. 23rd November.
Supplementary list item number 10.
I am on VC, my lord. I am for the petition.
Last occasion, on 18/5, Lordship granted time to file an affidavit with regard to feasibility of providing an underpass at Chandanpur, my lord.
Yes.
My affidavit is ready, my lord. In course of the day, I'll file affidavit. Let it come tomorrow or next week, my lord. So
all right. NHI states that he'll be filing an affidavit during the course of the day with an advance copy to counsel of the petitioner. Rejoinder thereto if any be filed before the next date. 2nd November.
Supplementary list item 11.
Item 11, may I please your lordship, my lord? This is a public interest litigation. Last time your lordship has the petitioner, senior advocate of this honorable court has raised grievance against the opposite party, the government officials, my lord, for not taking care of the public parks and playgrounds. I have filed additional affidavit stating the photo, indicating the photographs. I have affidavit, my lord.
Where is that?
Additional affidavit, my lords. Additional affidavit, my lords.
What does it show, sir? Nothing. It's not showing any.
In the annexure A by 2, there are some.
Developing a playground is different from maintenance of a park, sir. You're confusing the issues now.
No,
the original prayer was for improvement of the park.
This is for the playground. Some of the contractors are encroaching by stacking steeps, stands, and other things.
Is that, my lords? In the meanwhile, this land has been transferred to Cuttack Municipal Corporation, my lords. My further instruction is that Cuttack Municipal Corporation, with the assistance of the SAI, is undertaking also a development of an indoor stadium there. What is my instruction?
So let the CMC come then. You are appearing for whom?
Cuttack Development. We have already.
Mr. Vapatra appearing for the Cuttack Development Authority states that the land in question has been handed over to the Cuttack Municipal Corporation.
Cuttack Municipal Corporation.
Bracket CMC. Notice be issued without copy of the petition be served on Mr. Devashish Naik, then it comes to the CMC for him to obtain instructions. You please serve a copy on Mr. Naik.
Yes, ma'am. Yes, ma'am.
He's OP4.
List on 29th September.
Supplementary list item number 12.
Well, by law, in compliance of order dated 33/2022, I have filed the report on 5/7/2022, but the thing is that report has not been received.
Yes.
Now filing the hard copies that is available with me.
You have a copy of that?
Yes, report. I have the copy of the report, my lord. And yesterday also I have been served with a copy of a IA.
Who has filed the IA?
IA filed
by the opposite party number 1.
One, my lord.
To grant some time to file the counter affidavit.
Yes, in the report, my lord, they have admitted the transfusion of the infected blood. And the RDC has recommended certain measures to be taken.
All right. You say a detailed an affidavit has been filed by the Revenue Divisional Commissioner Sambalpur, bracket RDC, enclosing the detailed inquiry report into the issue of single quotes HIV blood transfusion at Vimsar Burla, unquote, which occurred in the second week of June 2016. So, a series of suggestions have been made in the said report. Full stop.
This is page 10, my lord.
Copy of the report is already available with opposite party number 1, which has filed an IA seeking more time to respond to the report. Which is that IA? They say IA to be numbered back on top. Time is granted to the state to file its reply specifically with reference to the suggestions made in the report of the RDC on or before 30th September 2022. Advance copies of the said affidavit shall be served on counsel to the petitioner and counsel to the other parties. List on 13th October.
Yes. Supplementary list item number 13.
Well, Your Lordship, may kindly see order dated 12/4/2022, my lords. My lords, Your Lordship was pleased to issue notice directing the opposite parties to file replies within 4 weeks and to respond the reply, my lords, so that the matter could have been heard today. Yesterday evening only, after 3 months, I was given a copy of the counter.
All right.
I will be taking only 10 days time to respond to this. Because you also permit to file rejoinder and matter will come up in August at least any day. ITA belongs. And judgments are there. All the questions have been answered by various courts. Honorable Delhi High Court, MP
Rejoin to be filed for the next date. Interim order to continue.
Interim order to continue.
Order, I don't know how to put repetition.
Short date will fix.
List on 17th October.
I thought probably sometimes in August you also.
No, interim order is there, sir.
Interim order is there.
Sorry.
Obliged.
Item number 14.
Lord, copy of the supplementary counter affidavit has not been served on me. So, Lordship, may kindly see the last order. In spite of your Lordship's order, Lord, I have not got the copy, Lord.
All right. Copy of the supplementary counter affidavit be served on consent of the petitioner within 2 days. Rejoinder for the next week. 21st November.
No.
21st November. Supplementary item 15.
My Lord.
Sir.
No interim order. No. Short date.
It's all right, sir. Yes.
Item 15.
May it please your lordship, I am through virtual.
I'm appearing for opposite party.
May I please your lordship? I am for the petitioner, my lord. And we will file rejoinder to the counter filed by the state, and we will file one objection filed by objection to the IA filed by the opposite party number 8 to 10.
Flush is the suppression of facts. So, I mean,
we will file objection
from the face of the record. They have not even followed the PIL rules, and there's a suppression. He's filed an earlier application, and they've suppressed it not only in this writ application, but the earlier writ application, which also your lordships had dismissed it. And the CMA.
Let him file a rejoinder then. Let him file a rejoinder.
And we will file objection
Sorry for the intervention, your lordship. Sorry for the intervention, your lordship. I am on behalf of Sonia Mathur, senior advocate, my lord. The petitioner engaged senior advocate and the brief transfer to him.
Sorry, the petitioner is engaged a senior advocate.
Yes, my lord.
No, we will engage. We will engage to Sonia Mathur.
All right. Do you wish to file a rejoinder?
Yes, your lordship.
Where are you appearing from?
My lord, I am from New Delhi, your lordship.
From Delhi. I see. All right. Mr. What is your name, please?
My name is Tirth Kumar Sahu, associate of Sonia Mathur.
No. So you are filing a wakalatnama today?
Memo of appearance, your lordship.
No. How does it work here? Anyway, one Mr. Tirth Kumar Sahu states that he will be appearing in the case and has filed his memo of appearance. He seeks and is granted time to file rejoinder before the next date. Grateful.
My short prayer is let the miscase which I filed be taken up before the matter is taken up on merits. That's my only short prayer.
All right, that's 9558.
9558.
Or IA 9558. This is an application by the opposite party number 8 to 10.
8, 9. Against whom the entire
opposite parties 8 to 10 seeking dismissal of the application on the ground of suppression of facts. Notice, Mr. Sahu accepts notice. Reply also be filed to this application before the next date. List on 16th November. Right.
Grateful.
All right.
Item 16.
Permitted to withdraw. There's a memo filed seeking permission to withdraw the petition. Dismiss this withdrawal.
Here, in this case, my lords, is squarely covered by your lordship's order, judgment dated 15/2/2022. That is a change of opinion and assessment reassessment cannot be initiated. Here, my lords, I will demonstrate how it is covered by your lordship's judgment. Lordship will kindly see Annex 2. For the assessment year 14-15, an assessment order under section 143 bracketed 3 was passed. That is at page 18. I challenged this order before this honorable court. And this honorable, on the ground, I challenged that the proper officer who has no jurisdiction to issue notice under section 143(2) has not issued it. And I have also quoted the order of this honorable court dated 6th of March 2019. I am supplying the. This honorable court, my lords, set aside the notice issued under section 143(2), but left open the assessment order. Said that whatever remedies are available, you challenge it. That your lordship will get in the operational portion.
Right.
Then
those are appealable orders, correct?
Appealable order. So far as the notice is concerned, that was set aside. 143(2) notice was set aside. But the remaining part remained. Actually, once the notice under section 143 is set aside, then entire assessment order becomes inoperative, I mean not in force. However, the department challenged it before the Supreme Court. Now, in the meantime, what happened, my lords?
They withdrew the notice.
They reopened the assessment by issuing a notice by the Annexure 5 at page 25. My lords will please to get.
Right.
Then, my lords, by the Annexure 6 at page 26, I asked them to furnish me the reasons. Now, the reasons your lords will find at page 28. It starts from 27. The relevant reason is 28. The self-same reason which was there in the original assessment has been reproduced.
No, there was a tax audit report at the original assessment itself.
Yes, that original assessment, my lord, the same has been dealt. I'll take your lordship to that page. That is, your lordship will kindly see.
Page 18.
At page 19, para 1.
Yeah, perusal the tax audit.
Yes.
Right.
Then, my lords, the assessing
same cost of medicine, everything.
Yes, yes. And lordship will see page 20, the next page. Amount is 2014-01-005. And the same thing, they have repeated it.
No, this you've accepted this assessment order.
My lords? Yes. Okay. We did not challenge it before the appellate authority, because once the notice has been set aside, automatically, if there is no head, why there will be headache? So I did not challenge it. They challenged it before the apex court. Now,
I'm on this assessment order of 30th December 2016, page 18.
Yes.
No, that assessment order you did not challenge.
No, I did not challenge. That remains till date. Now, my lords, the reassessment reasons, lords will kindly see the reason furnished to me, para 1, para 2, same thing, and that your lords will get it at page 21. Page 21, para 2B.
No, sir. Just to be clear.
Yes.
In this order which you showed.
Yes.
The High Court, this bench did not set aside this assessment order, although you challenged this assessment order.
Yes.
Saying it is appealable.
Saying it appealable.
But you have not appealed against it.
No. I did not file any appeal.
All right.
It is clear.
All right.
Now, on the self-SEM,
correct,
on which the assessment was completed.
Right, let me ask him. Yes.
Chimanka is on.
Yes, Mr. Chimanka. You have to unmute. Yes, Mr. Chimanka.
That filed also a counter affidavit.
Now you can talk.
Yes, I have filed counter affidavit in that regard.
Counter affidavit is very interesting, my lords. I'll take your lordships to the relevant portion of the counter affidavit. Lordship will kindly see page 2 of the counter affidavit, para 2.2. That the order of the Honorable High Court is not acceptable. My lords got it?
Yes.
Because the assessee neither challenged the notice issued by the lords. They made a postmortem.
Correct.
And how can they say it's not acceptable?
Correct. Anyway.
My lords. Now
No, but about change of opinion, what is your point, Mr. Chimanka?
Yeah.
Mr. Chimanka?
Yes, my lord.
What is your submission in reply to his submission on change of opinion?
He's laughing.
There's nothing, sir, because the reasons provided to him merely reproduce again the tax audit report.
Yes, we have provided the reason for the.
That's right. It merely reproduces what is there in the original assessment order itself.
Yes.
Nothing new. Correct. The challenge in the present petition is to a notice issued to the petitioner under section 148 of the Income Tax Act 1961 bracket Act dated
31st
March 2021 and the what is this order of disposal of objection by national?
Yes, that is
and the order and the subsequent order dated.
Yes, Annex 9, page 43.
And the subsequent order dated 28 January 2022 of the National Faceless Assessment Center bracket NFAC New Delhi, rejecting the objections filed by the petitioner to the reopening of the assessment, to the reopening of the assessment. Full stop. The reopening was sought to be made of the assessment which was completed on scrutiny for the assessment year 2014-15 by the assessment order dated 30th December 2016. Full stop. It must be noticed at this stage that in the course of the said assessment order, a notice had been issued to the petitioner under section 143 bracket 2 of the Income Tax Act, not by the authorized officer, that is the Commissioner of Income Tax bracket OSD bracket exemption, but by the Assistant Commissioner of Income Tax Corporate Circle 1 bracket 2 bracket ACIT. Stop. When the petitioner challenged both the assessment order dated 30th December 2016 as well as the aforementioned notice under section 143 bracket 2 of the Act in a writ petition being WP Civil 898 of 2017 in this court, the said writ petition was disposed of by setting aside the aforementioned notice under section 143 bracket 2 of the Act on the ground that it was issued by an authority who did not have jurisdiction to do so, namely the ACIT. However, this court, by its order dated 6 March 2019, did not interfere with the assessment order on the ground that it was an appealable order. Paragraph today, Mr. Siddharth Rai, learned counsel for the petitioner, confirms to the court that as of date, the assessee has not challenged by way of appeal the said assessment order dated 30th December 2016 for AY 1415, paragraph. In the objection filed by the petitioner on 26th May 2021 to the impugned notice dated 31st March 2021, after receipt of the reasons for reopening, the SSC pointed out that the reopening was based merely on a change of opinion and not on any new material that was come across by the authority, by the department. Full stop. The NFAC has, by the further order dated 26 May 2021, rejected the negative the objections. Paragraph. This court has heard the submissions of both Mr. Rai, learned counsel appearing for the petitioner, as well as Mr. Chimanka, learned senior standing counsel for the department. Paragraph. The perusal of the reasons provided by the department by letter dated 13th May 2021 for the reopening of the assessment for the aforementioned AY 2014-15 reveals that it refers to the tax audit report and the information available in the books of accounts of the petitioner. Full stop. It then proceeds to say, open quotation from the above details, it is revealed that the trust is selling the medicine with huge margin of profit, ... unquote. Interestingly, if one peruses the original assessment order dated 30th December 2016, in identical terms, the assessing officer states, open quotation, on perusal of the tax audit report, it is revealed that except other activities, ... unquote. Interestingly, the original assessment order, also in a tabular form, sets out the cost of medicines and the sale of medicines and concludes, open quotation, from such details, it is revealed that the trust is selling the medicine on huge margin of profit, ... unquote. Paragraph. This is perhaps a textbook example of a reopening of assessment being sought to be made on exactly the same materials that are available to the AO in the first instance. Paragraph. This is precisely what has been disapproved by the Supreme Court of India in its decision in Commissioner of Income Tax versus Kelvinator of India Limited 2010 320 ITR 561-AC, where it is observed as under, just take A to A. Paragraph. This court too has, in similar circumstances, following the above judgment, set aside a reassessment notice and a consequential assessment order by its judgment dated 15th February 2022 in writ petition civil 25229 of 2017 bracket Messrs. Stuff Tubes Orissa Private Limited versus the Deputy Commissioner of Income Tax. Bracket. For the aforementioned reasons, this court cautious the notice dated 31st March 2021 issued to the petitioner under Section 148 of the Act and the consequential order dated 26th May 2021 of the NFAC, rejecting the objections of the petitioner to the reopening of the assessment. Full stop.
Obligement.
The petition is allowed in the above terms, no orders to cause.
Item 18.
Second one, my lords, I have filed one amendment application to bring on record the order of the tribunal which completely answers the reopening notice, that is for the assessment year 16-17. So may I pray most humbly that the amendment may kindly be allowed and the order of the tribunal may be brought on record, my lords.
All right.
And I'll carry out the, my lords, I'll carry out the amendment by Monday, my lords. I'll file the consolidated copy.
All right.
Consolidated copy may kindly be given.
IA number 6668 of 2022 for the reasons stated therein. The application is allowed. The consolidated writ petition be filed within 2 weeks. The main writ petition you say list on. 29th November, interim order to continue.
Much obliged.
Supplementary list item 19.
May I please, my lords?
Yes, please.
The challenge of this writ petition, my lord, is an order passed under 148A(d), my lords. Essentially, I challenge this order, my lord, is that the officer, my lord, he has traveled much beyond the show cause notice, my lords. For your lordship may kindly turn to page 18. And
you have not filed a reply.
Yeah, I have filed the reply, my lords. I have filed the reply. What he has done, my lord, is may I just place
No. He has not filed a reply to the writ petition.
Yes, yeah, he has filed a reply.
But that's not come on record. Where did you file it?
My lord, I filed it, my lord, 10/6/2020.
It's there? Yes. Oh. All right.
So may I just place Annexure 2 at page 18, my lords. I'll need not take your lordship to the first paragraph. The reasons he has quoted in my 148A(d) notice.
Yes.
You have purchased immovable property with a consideration amount of rupees so and so during the financial year of 17-18, relevant to the assessment year 18-19. So you have made an investment of 110,60,000 in purchasing the immovable property. However, in the ITR filed by you for the relevant assessment year, fixed assets has been disclosed at ₹0, loans have been disclosed at ₹0, and the total income has been disclosed at 629,860. As you have failed to disclose the source of such huge investment made of rupees so and so by you during the said financial year, therefore you are required to show cause as per the provisions of section 148A(b) of the Act, that why such investment of rupees so and so will not be treated as your escaped income from the income from other sources under section 147 of the Income Tax Act 1961 for the assessment year 18-19, and why notice under 148 will not be issued to you for the relevant assessment year, my lords. Then, my lord, he deals with my 148A(d) order. He considers my show cause, my lords, picks up certain relevant materials from that. He switches over, my lord, to 56(2)(10)(b), my lords. May I just place it? The SSC furnished her submissions through e-processing on 18/3/2022 and uploaded relevant documents which were produced. The SSC has purchased the property as a joint owner of Sri Girija Prasad Dutt, PAN number so and so, with a consideration of 90 lakhs against stamp duty value of rupees so and so. That means the SSC has acquired immovable property for a consideration amount, the stamp duty value of which exceeds the consideration as per provisions of section 56(2)(10)(b) during the year. Although the consideration amount was paid amount paid was from earlier years' savings, but income from other sources of rupees 10,30,000, 1 crore some odd minus 90, as per the provisions of section 56(2)(10)(b).
Even that arithmetic is not quite correct, isn't it?
No, that arithmetic is not correct. It should be 20.
2060.
20. It should be 2030.
2060.
60, my lords. My humble contention, my lord, is
then he's because you've jointly purchased. I think he's reducing it by half.
By half. But what he has done, my lord, is the fact that I have bought this property from my relative, my lords, is taken into consideration. But unfortunately, he does not consider the proviso to section 56(2)(10)(b), my lords. If your lordship would see, my lords, I have. Let me take your lordships to my reply, my lords. That is at page 23. May just please,
yes.
Page 23.
Yes.
Kindly refer to your notice 148A dated 11/3/2022, cited above, issued in my favor, wherein it has been alleged that I have purchased immovable property for consideration amount of rupees so and so is not correct. Although I have purchased immovable property belonging to my husband's ancestors and the consideration amount of rupees so and so, jointly with my husband, Sri so and so, PAN number so and so, for the
I think you're reading some other. This is 10229, right?
No, 10224, my lords. The first case.
Oh, I see. All right.
Page 23, my lords.
Right.
So I disclose the fact that my husband's ancestors had sold this property, my lords. And I have also annexed the sale deeds at page 33. I'll just take your relevant portions to the sale deed, my lords. At page 33, my lords. Running page 33. Your lordship, what?
Yes.
Paragraph, whereas the vendees happen to be the nephew and daughter-in-law of the vendors. And your lordship knows that the proviso to section 56(10), I'll place that proviso, my lords, excludes certain classes of relatives from the purview of section 56, my lords. May I just place that, my lords? Section 56, my lords. Lord, section 56(2), my lords. 10B, my lords.
Yes.
I'll just place section 56(2) first. In particular, the lordship got it?
Yes, and without
income from other sources. In particular and without prejudice to the generality of the provisions of subsection 1, the following incomes shall be chargeable to income tax under the head income from other sources. Namely, then the lordship may come to 10, my lords, small Roman 10, my lords, where lordship,
yes,
where any person receives in any previous year from any person or persons on or after the first day of April, your lordship may skip A, come to B, my lords, any immovable property without consideration that is not relevant, capital B, my lords, for a consideration which is less than the stamp duty value of the property of an amount exceeding 50,000 rupees, the stamp duty value of such property as exceeds from such consideration, provided, then your lordship may come to the fourth proviso, my lords. Provided that this clause shall not apply to any sum of money or any property received from any relative. And relative, my lord, has been, if your lordship would see the explanation, relative has been explained in clause 7, my lords. Lordship got it? At the bottom, my lords. Clause 7. For the purpose of this clause, expression SSE, fair market price, jewelry, property, relative, so and so, shall mean assigned to them in explanation to clause 7. Then the lordship may kindly turn to clause 7, my lords. Relative means, lordship, E.
Go earlier.
Explanation, my lord, explanation E, my lords.
Right.
E. In case of an individual, spouse of an individual, brother or sister of an individual, brother or sister of the spouse of an individual, brother or sister of either of the parents of the individual, this will also be important, my lords. Then any lineal ascendant or descendant of the individual, not F, my lord, any lineal ascendants or descendants of the spouse of the individual, my lords. So my specific case before him was my vendees were the uncle of my husband, my lords, who had sold it. And the sale deed, my lord, I had taken that specific stand in my show cause. I have annexed the sale deeds, my lord, which described them as uncles of my husband, my lords. And still, my lords, he gives a go-by to the main stamp duty part, applies 56(10)(b), but unfortunately misses out that these relatives from whom I have purchased, my lord, will not be amenable to 56 minutes.
But just out of curiosity, how come the sale consideration is 90 lakhs?
My lords.
And the stamp duty is 1 crore and 10 lakhs.
No, it's a dilapidated house because the stamp duty is paid on the benchmark value fixed by the government.
Right.
But I pay the price on the value of the property as per negotiation with the owners of the property. It's a dilapidated house, that has been described also in the sale deed itself. If your lordship would kindly come to the description of the schedule at page 40, Gharabadi 2, Kisam Homestead. Area of sale is 120 decimals, over which an old dilapidated double-storied building of common cement flooring and load-bearing tiles of roofing and of the vendors and the vendee. Because your lordship will get it at page 40 of the sale deed.
Right.
In fact, it was a joint dwelling house of the vendors and the vendees. The vendees, they wanted to sell away their share.
I think in handwriting, it says the consideration amount is 110 crores.
The consideration amount is 110 crores because that is the stamp value which has to be disclosed. Otherwise, it can't be registered,
Oh, yes, because it's a circle rate.
It's a circle rate,
Right.
So in this situation, once he goes out on a premise, that this is the stamp duty value or whatever, he says that. He gives up that, does not consider, my objections under 148 8B, and your lordship knows, the onus cast on the authorities is much more than what was contemplated in GK and Drive Short, GK and Drive stopped short, of only giving me reasons. But the legislature, in its wisdom, they said that the authority has to decide my case, my show cause notice under 148AB, which I've given in 148AD. And I've extracted, 148AD, and your lordship knows it, that he has to decide on the basis of materials available on record, So the onus cast is a heavy onus, before he proceeds to 148, So he goes beyond the
148AD's AB or AD is also appealable.
No, great respect, it is not.
Okay, there's no provision for
There's no provision for an appeal so far as 148AD is concerned. Okay. Great respect.
Right.
But the onus, cast on him to decide, is much heavy than GK and Drive Short, which did not contemplate of such a situation.
All right.
And
yes, Mr. Satpathy. Open and chatter.
Lord, I don't want to praise anything more. Lord, I may, without recording my conscience, Lordship will direct to reconsider this issue again.
Why should he reconsider,
No, because
both the husband and wife, they have suffered a lot. With great respect,
with sincerity, I may say.
The earlier case which your lordships are saying, the notice was squashed, but
that is something different, Lord. That is change of opinion. But here is a case, Lord, admittedly, in view of the amendment, Lord, he has been noticed and he has filed a reply.
So what? So what? You have to still defend the order.
No, defend
the order. Facts are so telltale. It's all obvious.
But Lord, your lordship see the order. Whatever my senior is saying, Lord, it is correlated. 56 is correlated. What was the issue before this authority and notice and issued? This is relating to 56, Lord. Maybe, Lord, I made to say that it has not been considered. Therefore, Lord, I considering to that effect, Lord. Your lordship may direct to reconsider this issue because he has filed a petition before this.
Why multiply litigation? If you have something to say it now and here. See, that's why you are asked to file a counter.
Yes, but that counter in my counter I have said. Your lordship, see.
Because our experiences, when you remand the matter, man repeats the order.
No, your lordship clarify the
No. If there's something else apart from what you've said in the counter, we can understand.
Yes, Lord. In counter, your lordship, I have stated in para 9. Lord, para 9 start from.
No, the same thing. It exceeds the value. Stamp duty exceeds the value of actual consideration.
No,
that's all.
Therefore, as the petitioner has acquired the more property consideration amount, the stamp duty value which exceeds the actual and the provision of 56(2)(xb), the act is automatically attracted, which petitioner has failed to explain.
No, he has. In fact, he has said all this in his objection.
And he says, my lord, he has gone through the relevant documents uploaded as well as my explanation, lords, in his order, lords. And this is the understanding and this is the decision, my lord, your lordship would appreciate. Contrary to the provision itself, my lord.
Therefore, my lord, I humbly say, my lord, The notice has been issued with, there is no lacuna so far issuance of notice 148. With due approval has been issued. There is no, there is no problem. Notice are issued with the regions that has been communicated to him, and he has filed a reply. And most
no, but even in your counter, you keep on saying he could not furnish an explanation. He could not. He's actually filed a reply.
Yes, Milord. That is what Milord.
And you don't refer to that at all.
Without saying anything, that's what Milord. I insist Milord, given that your Lordship, please to direct that you should reconsider so that Milord matter could have been settled.
I don't.
Otherwise, Milord, create the order. If the Lordship quash the order, then it will be.
My Lord, your Lordship's order has to create a precedent. No, that cannot be. It has to create a precedent.
I cannot.
So it can't be an escape route, my Lord.
I cannot develop. Accepted the petition content. So much, Milord, sincere, Milord. I only pray that may reconsider. Objection, your Lordship made. So that Milord, they may not create and further this type of order.
All right. These two writ petitions arise out of a similar set of
They're
facts.
the wife and husband, my Lord.
That's right. And are accordingly being disposed of by this common order. While writ petition civil 10224 by
separate
Mamta
order,
Datta.
separate order. Both are separate order has been passed.
Yeah.
Separate.
10229 is by her husband, Girija Prasad Datta. Full stop. Paragraph. Notices under section 148 of the Income Tax Act for the assessment year, bracket AY 2018-19, both dated 30th March 2022 were issued to each of the petitioners, seeking to reopen the assessments made for the concerned AY. Stop. By separate communications dated 28 March 2022. No, you say in each of the notices, it was stated that income chargeable to tax had escaped assessment.
One 148AB notices at attention 4 series, page 21.
According to the department, the petitioners had purchased immovable property with a consideration of rupees 1,10,60,000 during the relevant AY 2018-19. Whereas in the income tax returns bracket ITR filed, each of them had disclosed income of rupees 629,860. Full stop. Stating that the single quotes huge investment unquote had been made to the tune of rupees 1,10,60,000 out of their single quotes undisclosed income during the year. Stop. In terms of section 148, capital A bracket small b of the Act, each of them was asked to show cause why the said investment amount should not be treated as the escaped income from other sources, and why notice under section 148 of the Act should not be issued to each of them. Paragraph. In response to the notice under section 148 capital A small b of the Act, each of the petitioners filed a reply dated 18 March 2022. Full stop. In the reply, it is specifically pointed out that the property that the immovable property purchased belonged to the purchased jointly by both of them was for a consideration amount of rupees 90 lakhs, which had been paid from the joint account maintained by the two of them. And in particular, that the immovable property purchased belonged to the ancestors of Girija Prasad Datta. So the property was an undivided property, as though there was a partition suit and decree. But there was no final decree demarcating the shares, for which the uncles of Girija Prasad Datta, out of their love and affection, and also to maintain the ancestral property intact, had agreed to receive rupees 90 lakhs. Full stop. The source of investment in the immovable property was the earlier year's fixed deposits, which had been encashed during the year. The details of the fixed deposits were fully disclosed in the reply. Full stop. A copy of the sale deed was enclosed, which showed that for the purpose of stamp duty, the consideration was indicated as 1,10,60,000. And on that basis, the stamp duty had in fact been paid. Full stop. The narration in the sale deed explained that the structure on the land in question was a dilapidated one, which explained the difference in the actual sale consideration paid and that indicated in the sale deed. Paragraph. It may be mentioned here that reply on the same lines were filed by both petitioners in response to the notice under section 148 capital bracket small b of the Act. Paragraph. The impugned order was passed on 28th March 2022 under section 148 capital A bracket small d of the Act. Noting the fact of joint purchase of the property for a consideration of rupees 90 lakhs against a stamp duty value of rupees 1,10,60,000. And making the obvious conclusion, inference that open quotation stamp duty value ... exceeds such consideration, unquote, but invoking section 56 bracket 2 bracket Roman small 10 bracket small b of the Act. Full stop. The difference being rupees 20,60,000. The sum proposed to be added as escaped income was rupees 30,000 in hands of each of the petitioners. Full stop. An identical line in both the orders in the respect of each of the petitioners is that, open quotation, the assessee could not furnish any explanation regarding such escapement of income, unquote, for AY 2018-19. Full stop. Paragraph. Mr. R.P. Learned, counsel appearing for the petitioners, points out that in passing the above order, the authority has failed to notice the exception carved out in section 56 itself. Read with the no, this will be a sixth proviso, I think, no?
Quote the
because now there's, I think, two more inserted. There are two provided also, and then there's a provided. Sixth proviso to section 56, bracket 2, bracket 10, Roman small 10 of the Act, which exempts the applicability of the provision to, open quotation, any sum of money or any property received, one from any relative, unquote. The expression relative has been defined under section 56, bracket 2, bracket Roman small 7, bracket small e, to mean one in case of any individual. Then you say ... E, any lineal ascendant or descendant of the individual. F, any lineal ascendant or descendant of the spouse of the individual. Then you say ... Paragraph. Inasmuch as the vendor of the immovable property was an uncle of Sri Girija Prasad Datta, he would fit the definition of single quotes relative. And since the property has been received from such relative, the provisions of section 56, bracket 2, bracket 10, read with the sixth proviso there too, would be attractive. And the income would be exempt from tax. Full stop. It is seen that Mr. T.K. Satpathy, on the other hand, refers to the reply filed in the present petition, where what is stated in the impugned order is simply reiterated, namely that the stamp duty value exceeded the sale consideration, thereby attracting section 56, bracket 2, bracket
para 8 and 9.
10 bracket small b, and repeating the phrase that the assessee could not furnish any explanation. Stop. Paragraph, the above submissions have been considered. Full stop. The court finds that under section 148, capital A, bracket D, the assessing officer is obliged to decide, comma, open quotation, on the basis of material available on record, including reply of the SSC, whether or not it is a fit case to issue a notice under section 148 by passing an order, ... unquote. Full stop. Clearly, therefore, it was essential for the authority to have not only considered the material available on record, but also the reply of the SSC. Full stop. In the present case, the replies of both the SSCs made a specific reference to the fact that the property in question had been purchased for a consideration of rupees 90 lakhs from the uncles of Shri Girja Prasad Datta, disclosing also the sources of income. Full stop. The obvious full stop, the sale deed had also been enclosed. Copy of the sale deed had also been enclosed with the replies. Full stop. If the assessing officer was going to refer, which he did, to section 56, bracket 2, bracket 10, bracket small b, then obviously it could not have escaped his attention that in terms of the sixth proviso to 56.2 bracket Roman small 10 of the Act, an exception is provided where the property in question is received from a relative. Full stop. Paragraph, Mr. Satpathy pleaded before the court that the matter should be sent back to the officer for a fresh decision to be made after considering the reply of the SSC, and in particular the above exception. Full stop. The court is of the view that this will needlessly multiply proceedings when the facts are clear, as is the law. Full stop. The assessing officer in this case has overlooked the legal position, and with the facts being an admitted position, there is no need to send the matter back to him for a fresh decision. Paragraph. In that view of the matter, the impugned order is dated 28 March 2022 of the assessing officer under section 148 capital A, bracket D of the Act, and a consequential notice dated 30th March 2022 under section 148 of the Act are hereby quashed. The petitions are allowed in the above terms and orders.
Greatly obliged, much.
Supplementary list for hearing item 21.
May I please, Your Lordship? Your Lordship, we freshly file our affidavit and the conducting my senior, Mr. Vijay Kumar Ragada, out of station for sessions trial. Kindly pray for any short adjournment.
We don't accept this, please. If this matter was adjourned, I think, at your request.
But we are filing our affidavit freshly.
Affidavit?
Pardon, my lord, wakalatnama.
Last time, Sponda was engaged.
We are newly engaged.
Why don't we proceed with the legal aid counsel? You can file your written submissions. Coming at the last minute and filing a wakalat is not going to help.
No, my lord. Here, my lord. Sorry, my lord. My partner, I am virtual mode, my lord. Virtual mode, my lord. Virtual mode, my lord. We appear, my lord, with consent of the apparent earlier advocate, my lord. We request any date, Your Lordship.
The appellants are directed to appear today. The appellants are directed to appear today. And my instruction is they are with my learned friend, Mr. Patel.
Where are they? Where are the appellants? Where are the appellants, sir?
My lord.
Where are the appellants?
Lordship, request short date. Any Monday, my lord. Request we appear, my lord.
What is your name, sir? Mr. Patel?
Yes, my lord.
Mr. Patel, would you mind listening to us for a minute?
Yes, my lord. Yes, my lord.
So kindly tell us, have you seen the previous order passed by us?
No, my lord.
Could you then either you come down here, sir, or if you have a copy, please read it.
No, my lord, we have no copy, my lord.
Problem is, sir, we have copies of our order, sir, and we're reading it. And the order required the appellants to remain present in court.
Monday, my lord, I will.
Sir, please kindly listen.
Yes, my lord.
We're only hearing the one word from you, Monday. There is no answer to the question we are asking you.
Yes, lord.
What is the question we are asking you, sir?
Lord, see, where is the appellant? My appellant is on bail.
Are you aware where the appellants are?
Here, my lord, he is in village, my lord.
Where?
He is village, my lord.
Sir, he is asked to remain present here.
Yes, my lord.
We are going to straight away cancel his bail, ask him to be arrested.
Monday, my lord,
we are going to ask him to be arrested. We take a very serious view of this, Mr. Patel. We take an extremely serious view of this matter. This is a criminal matter. Your client is a convict under Section 302. He's in appeal. He's on bail.
Yes, my lord.
He's willfully disobeyed an order of this court.
Monday, my lord, we are
Mr. Patel,
yes,
will you stop saying Monday? Will you understand the real seriousness of this? Everything is Monday for you.
I'm also.
Don't keep on saying Monday. I don't want another time for you to say Monday now.
Mr. Raghav,
you have put your clients in great difficulty.
Sorry for that, my lord.
You don't have to be sorry.
I beg apology.
You are not even aware of the order passed by the court. That's the biggest problem.
Yes,
you don't know what order has been passed.
Yes, my lord. I do not know.
It's an extremely serious matter. We are cancelling the bail right away. We are going to ask the IIC to immediately arrest.
No, my lord.
Immediately arrest the appellants, put them into custody, and then we'll take it up on whichever date you want.
I pray, my lord.
There has to be a seriousness. Sorry.
I beg apology, my lord.
Sorry, Mr. Patel. You've taken it too casually.
At least tomorrow.
You've taken it for granted that a high court order can be disobeyed willfully.
Tomorrow
I'm sorry, we will not tolerate a high court order being disobeyed. Not in a criminal appeal.
They have come to the high court.
Not in a criminal appeal.
1 day time, 1 day.
Sorry, Mr. Patel.
You
say on 23rd June 2022,
I pray
an order had been passed specifically requiring
the
appellants
1 minute,
to remain present in the court. Today, the date was fixed as 21st July 2022. Today, Mr. Patel says on virtual mode that he has entered appearance for the appellants. He states that he is not even aware of the order passed by this court on 23rd June 2022. In fact, he did not have even a copy of the said order. He then states that the appellants are in their village. Full stop. Paragraph, the court finds this completely inexcusable. Notice was served on each of the appellants through the concerned IIC.
My instruction, the IIC's instruction is they have come to the High Court and they are here.
Yes, sir, they have come, my lord. In my office, I have taken consent from the power.
Sir, I am repeatedly asking you, Mr. Patel, where are the appellants? You told me just now they are in the village.
No,
fortunately, this is a live streaming. Mr. Patel, just realize this, what you're saying. This is live streaming. My colleague is here with me. The entire court has heard you say that they are in the village. The entire court has heard you say they were in their village. And today you're telling me they are in the court?
No, Mala, I have no instruction, Mala, that.
Where is the IIC?
This IIC has not come because she said that they have come to Mr. Patel. And,
no.
The IIC of the concerned police station is required to immediately take the bail. You say the bail granted to both these appellants. How many appellants? 2 or 3?
Three.
The bail granted to the 3 appellants is cancelled.
No, my lord, I have beg apology.
The IIC of the concerned police station
my
will take them immediately into custody.
My lord.
And ensure that they are placed in jail custody.
One day, your lordship, time.
Paragraph.
I beg
apology. This appeal.
I beg apology.
For hearing next.
I beg apology. Sorry, my lord. My lord.
List this appeal for hearing on 8th September.
My lord, one thing, my lord. One day, your give me 1 day, my lord.
Call out the next
Item
matter.
22.
Kindly,
Copy of this order be served immediately on the IAC.
Supplementary list item number 22.
Item 22, my lord, on behalf of R.K. Raut, my lord, he is going to today morning. The brother is died, my lord.
Lordship, I apparent notice.
Legal accounts. Item 22.
22, my lord, I am on behalf of R.K. Raut, my lord.
We'll cancel the bail, sir. We'll cancel the bail in all these matters. I think all of you will then start appearing.
The appellant is present inside the courtroom.
The appellant is present.
Yes. बोला.
Whom are you asking adjournment for, sir?
My lord, I am on behalf of R.K. Raut, my lord. Ranjan Kumar Raut, my lord.
Sir, this adjournment request was made on 21st April, again on 23rd June.
My lord, today morning, the brother, Mr. Raut brother, advocate for the petitioner brother died, my lord. He go to the Puri, my lord, for cremation.
All right. It is stated that Mr. R.K. Raut, the brother of Mr. R.K. Raut, advocate for the appellant, has expired today. And he has left for Puri to attend the cremation. Pursuant to the paragraph, pursuant to the previous order, the appellant is present physically in court, identified by the learned additional government advocate. Paragraph. In the extenuating circumstances pointed out herein before, adjourned to 11th August. Just tell him 11th August. The appellant need not be present on the next date.
Supplementary list item 23.
Yes, personal appearance is dispensed with.
Yes.
Item 23.
Yes, my lord, I am for the appellant, my lord, in this case. Today I am filing my note of submission.
Carry on, madam. Carry on.
My lord, this matter is only convicted at the.
You just read the facts of the case, you can start reading it. Just read it. From here, whatever you've written, just read it.
My note of argument, my lord.
Just read from the fact of the case, from this paragraph. Yes. Kindly read from that sentence.
Yes. The fact of the case, the prosecution case is not self, is that on 13/8/2000 night at about 11 p.m. while Yudhishthira of Orissa injured was sleeping on a cot lying on his veranda of the house. His wife, deceased Mukta Bhaisa, was sleeping on the floor of the shared veranda near him. At the relevant time, the accused being armed screaming of the deceased woke up the accused also assaulted him by the said Budya. Hearing the whoi and cry, the Yudhishthira and Mukta, the informant PW1, who is the son-in-law of the Yudhishthira, and PW2, daughter of the Yudhishthira, who at the relevant time were sleeping in the another room on their house, come out of the room and noticed the accused running away from their house. And they also found bleeding injury on the person of the Yudhishthira and Mukta. On being asked by PW1, his father-in-law, PW13, told him that the accused Bhagwan assaulted Mukta and by Mukta by means of an X to her head and hand and also assaulted him on his head, leg and back by means of the said X. Hearing the ghastly incident, PW1 informed the matter to one Rohit Sethi, Hatia, Basantarana and other of the village who reached the spot, and since the condition of Mukta and Yudhishthir was very critical, PW1 made a necessary arrangement for shifting them to hospital. Then he reported the matter at Tikatpally PS. The shared case was registered as Tikatpally PS case number 21 of 2000. The list of witnesses from the side of the prosecution, as many 17 witnesses have been examined. Out of them, PW1 is the son-in-law of injured. Is the informant. PW2 is the daughter of injured. PW13. PW3 is the witnesses to extrajudicial confession made by accused. PW4 is the post-occurrence witness. PW5 is the doctor who examined the injured, Yudhishthir Bhainsa and Mukta Bhainsa. PW17 is the doctor who held autopsy over the dead body and of deceased Mukta Bhainsa. PW6, Dasaratha Muhakuda. PW12, the Debananda Dhar are witness to seizure of wearing apparels of deceased. Under Exhibit 8, PW7, Swadhin Kumar Mahakuda. PW11, Hare Krishna Pradhan are said to be witnesses to inquest under Exhibit 2. PW8, Lala Brahma is the witness to seizure of ROR. PW9, Harihara Kishan and PW10, Rohit Sethi are said to be the witness to seizure of bloodstained earth, sample earth and weapon of offense, that is the Buddhya MO1. Under Exhibit 10, so also witnesses to seizure with wearing apparels of accused, that is one bloodstained lungi. Under Exhibit 11, PW13, Yudhishthir Bhainsa is the injured himself as well as the eyewitness to the occurrence. So also a witness to inquest. PW14 is the formal witness. PW15 and 16 are the investigating officer. On the other hand, the accused has not examined any witness on his behalf to refute the charge leveled against him. The plea of the appellant is one of the complete denial and false implication. 5. The point of the argument that the prosecution mainly relied upon the evidence of PW13, who claims to be the injured himself, as well as the eyewitness to the occurrence, and so also a witness to the inquest. The law is well settled that the conduct of the sole testimony of the one eyewitness, if unnatural, the conviction can be based on the testimony of a single eyewitness. So long as he is found to be wholly reliable. In the present case, the conduct of PW13 sole testimony of one eyewitness in this case was unnatural and therefore highly unsafe without corroboration from other piece of evidence. And he has not seen the actual assault of the deceased. That the alleged occurrence have been taken place on 13/8/2000 and the FIR lodged on 14/8/2000. The inquest was conducted on 14/8/2000 in presence of PW13, but the IO PW15 stated in his evidence that he has examined PW13 on 16/8/2000, and therefore the delay in examination of eyewitness created doubt on the veracity of the prosecution case, and thus the appellant should have been acquitted from the charge leveled against him. That the evidence PW1 and 2 being the son-in-law and daughter of the deceased respectively cannot be relied upon as because they are not seen the occurrence, and they being the post-occurrence witness, and also the interested witnesses, and so also related to the deceased and the injured. Their evidence cannot be relied upon. That so far as the evidence of PW3 cannot be taken into consideration as because she stated he stated in her evidence that the accused made extrajudicial confession before him, and the accused on the relevant night, that is at 12 midnight, went to his house and woke up him and told before him that he assaulted his uncle and aunt by means of an axe in their house, and the PW3 allowed the accused to sleep in his house. Since the extrajudicial confession is a weak piece of evidence, it should not be relied upon as because the evidence of PW3 is doubtful, as because why the accused repose confidence upon him and the confessed is guilty. The conduct of PW3 is not believable as because he has heard from appellant about the incident on the date of occurrence night, as to why he has not disclosed the same to the family member of the deceased, or he has not reported to villagers or police, and he remained silent. Therefore, the appellant should have acquitted from the charge of libel against him. The alleged occurrence have been taken place on 13/8/2000 and FIR lodged on 14/8/2000. And the delay in lodging FIR has not been explained by the prosecution. The story of the prosecution is doubtful and afterthought, and therefore the veracity of the FIR is doubtful. The benefit of doubt should be given to the appellant. That initially the case was registered under 326/307 of IPC, though the alleged occurrence have been taken place on 13/8/2000. On the deceased died on 18/8/2000. Therefore, the appellant cannot be convicted under section 302 of IPC. Taking into consideration the manner of the assault on the deceased, the case is not coming under 302 of the IPC. At best, offense comments under culpable homicide not amounting to murder on 302 part 1, 304 part 1, 304 part 2 IPC. And since the accused is custody from 14/8/2000, the sentence imposed on him may be set off and he may be set at liberty.
Yes, please.
That in the present case, the prosecution failed to prove the motive behind the alleged incident, and in absence of motive, the conviction under section 302 cannot be sustained, and the appellant may be acquitted from the charge leveled against him. That since the judgment order of the conviction being otherwise unjust and illegal, and the same is liable to be set, and appellant may be acquitted from the charge leveled against him.
All right.
Yes, sir. PW 13 is the injured eyewitness.
Yes.
I'm reading the statement of PW 13 years.
Actually, this suggestion to him in the cross-examination is very strange. Just come to this cross-examination of PW 13. In para 9, he says, I had not seen while the accused assaulted the deceased.
Yes.
But the suggestion in para 11, it is not a fact that I sustained injuries while I tried to snatch away the axe from the accused.
That is very important. That is very important. That is very important. You'll also rightly picked up the point of the case.
Very strange. And that the accused had not caused any injury. This is really strange. He's an injured eyewitness. Why are they suggesting to him that he snatched the axe, which means he saw the assault, when he's saying he did not see the assault?
And here, there are two, so far as the doctor is concerned, that two injuries. Plus that is also will get it at page 84. The doctor loss.
Yes.
External injuries loss will also find past lacerated injury, stitched wound of size 7 cm into 3 cm. Bone deep over hematoma with fractured skull. Then to left forearm stitched wound 1 cm. The right lower chest bruise of size 8 cm into 4 cm with abrasion 8 cm on 10. And opinion is all the injuries were antemortem in nature and are sufficient in ordinary course of nature to cause death of a person. And the next page will also get it from paragraph 4, 85, page 85. That weapon of offense has been produced before him. On 5/9/2000 on police requisition, I examined one tangia produced by Havildar so and so and opined that the injuries mentioned in the PM report are possible by the said weapon, axe. This is my opinion report now marked as exhibit 15/2. And this is the said axe, already marked as a MO1. And here PW 13 says, which is the injured eyewitness, plus he was sleeping on the cot and the deceased was sleeping on the floor. So in the night, the accused has intruded in the house and gave a blow. So hearing the screaming sound of his wife, he woke up and then there must be a tussle because and there he has given him a blow. Plus paragraph 3, I am reading that paragraph 2 at the relevant time from third line I am reading. At the relevant time, the accused being armed with a budia, that is the axe, a sharp edged weapon, came to the spot and assaulted the deceased to her head near left side ear. Hearing the scream of the deceased, I woke up. And at that time, the accused assaulted with the axe to my left leg, causing injury when I tried to catch hold of the accused. And dealt another axe blow on my back, causing bleeding injury. And then I called my son-in-law and daughter who were sleeping inside the house. And hearing my cry, they came out and seeing them, the accused fled away from the place of occurrence. My deceased wife had snatched away the axe from the accused while the accused was assaulting me. So in that process, that axe was snatched away by the deceased, and she has handed over it to another Rohit Seth. What she has stated in the last line. My deceased wife handed over the axe to Rohit Seth, and subsequently both were taken to the hospital. And the hospital, the wife died. And PW3 recovered. And PW1 and 2 is a doctor as well as son-in-law. I am going to that. For a moment, I am taking a lawsuit to page 52. That is Gulab Mahakut, the doctor. Hearing the scream of my father, I came out from my room. Being followed with my husband and found that the accused was assaulting my mother by means of budia. While my father intervened, the accused also assaulted my father by the said axe. My father sustained bleeding injury on his head and back. One lamp was burning near the spot and the relevant time was moonlit night. And it has been corroborated, well corroborated by the chemical examination report even, the scientific evidence. That is, you will also find at page 89.
Blood group is B.
Page 89 of the paper. Tangia that was carrying human blood of group B, and one check lungi of accused, also the check lungi of accused, that was also carrying human blood. And then one yellow printed check sari of the deceased, that was human B.
So what are the injuries on PW13?
Yes.
Who has examined that?
Madam.
It will be 5.
PW 5. Plus PW 5, page 59.
He also got an injury in the head.
Yes. I examined the injured person's Mukta Bhaisa with the deceased.
Wow. 2 injuries on the scalp, 1 on the knee, and 1 to the back.
Yes. Inside wound over left forearm,
Seriously?
Inside wound over left parietal temporal region of skull with fracture. That is of deceased. And on examination of injured Yudhishthira Vansha, that is at page 60 belows. Paragraph 3. Incised wound over left frontal region of skull. Incised wound over occipital region of skull. Incised wound over left knee medial aspects. That was 4 incised wounds. All the injuries are simple in nature.
What do you say on this motive part? What do you say on motive?
There was
What does he say in his 313? When he is asked, do you have anything more to say? What is it?
313 plus, he has not explained anything. 48. He has not explained anything.
No. Page 48, there's something in Orissa. You can tell me what he says.
Plus 48 question.
That's it. Oh. And standard denial for everything.
It's a false. He has finally he has said I have been falsely implicated.
All right.
At page to question number 38.
All right.
And having an injured eyewitness, there was also sufficient light to see him. There is also the defense cannot say that there was no light in the darkness. He could not see the accused.
Well, witness number 13, page 74, 75. Para 8. The occurrence took place in the rainy season. There was no electricity in our house. That is the rainy season.
Adam, when somebody is standing at such close quarters, hitting your head, how will you not see?
Adam, that is a dark
He's himself
night.
an injured. He's got 4 injuries. 2 on his scalp. How will he not see the accused? Such close quarters. All right. Orders reserved. I think you file your written notice.
I'm just no filing.
All right.
No, I'm not no filing.
Orders reserved. Written notice submissions be filed within a week. On that motive, there is a lot of case law.
Yes, ma'am.
So please find that out.
And also, your lordship has decided in many cases.
No, but you find out there's Supreme Court judgments.
Ma'am.
All right.
Then I will give an additional list of citations.
My lord, I am also given one Supreme Court judgment.
Correct. Amar Singh. Amrit Singh or Amar Singh? Anyway.
Supplementary item 24.
May I please, my lord? On the last occasion, I had begun my submissions, my lord. I had shown PW21, who holds the key actually to this case. I had given a small 1-page note where all the relevant witnesses were mentioned, my lord.
Yes. Yes. That note is there.
My lord would see the important witnesses are PW21, PW5, 4, 13, and 25 is the IO. Now, PW21, if my lord may just see that relevant portion, which is at page 149.
Maheshwari Reddy. This is that when they come in one van or something.
Yes, my lord. PW21, the trial court peculiarly has not referred to as an eyewitness, but for all practical purposes, she is an eyewitness, according to the prosecution.
So this one thing about one person whom they see in that place,
yes,
supposed to chase them in a motorbike, smash that glass, And she says nothing about smashing the glass then.
No, I'll just explain. It's just a similar, that portion is at page 149. What she says is that on the date of occurrence, she was traveling from point A to point B. And on the way, she saw 6 persons assaulting. Now, when the Maruti van crosses that place, one of those people, they pick up a motorbike and chase that Maruti van.
Correct.
And at a place, that person breaks the windshield.
Correct.
This is her evidence.
Correct.
Now, that person who chased is also a prosecution witness, PW5. He doesn't say this.
Right.
The IO PW25, he doesn't
he
say
never
that
found any smashed glass.
smashed glass.
Correct.
And paragraph 8, when all this smashing took place, a lot of villagers gathered, police people also gathered. There, this witness doesn't say that there was a murder which I saw. So in that background, one judgment, if my lord would show, she's a chance witness. It says that she's a chance witness. In view of this conduct, post occurrence, we find it very difficult to disbelieve her. That judgment, my lords, is 2004 10 SCC, page 632, paragraph 5. If my lord wants, I can show that judgment straight up.
Highlighted portion.
Yes, my lord. Paragraph 5. Let me place that paragraph. Even according to the prosecution, the only witness to the incident in question is PW6. Therefore, as contended by the learned counsel for the appellant, we will have to examine his evidence carefully. If we do so, then we notice that on the date of incident, he had gone to village Upli for some work. From there, he came back by bus at about 11 o'clock. He then allegedly went to the village to meet Ramrak, where he was told by his wife that the latter had gone to the field. It is the prosecution case itself that the distance between the field of Ramrak and the village is about 4 to 5 miles, and PW6 covered that distance on foot. And when he reached near the field of Ramrak, he had a quarrel. And when he went towards the place of quarrel, he saw the appellant attack the deceased with an axe. It is his further case that when he reached near the deceased, the appellant ran away. It is at this point of time, he states that he got scared and he took a different route than the one he took on the way and reached the village at about 4 or 4:15 p.m. It is his case that when he went to the house of Ramrak, he could not find him, and therefore he came near the village square and where he met PW2 Khyali Ram. From the above evidence of PW6, it is apparent that though there were persons available, this my lord may kindly take note. From the evidence of PW6, it is apparent that though there were persons available on his way back, he did not inform anybody about the incident. Even when he reached the village, he met Ramrak's wife. He did not inform her about the incident, and it was for the first time he informed about this incident of PWT at Village Square at about 4:15 p.m. Contrary to what is stated in the examination in chief, that he saw only one assault on the deceased, in the cross-examination, he stated that he saw the appellant attack the deceased twice, and both the injuries were caused in his presence. It is also to be noticed from his cross-examination that when he met PW2 Khyali Ram and told him about the incident in question, PW2 supposedly told him that he had already come to know about the incident from PW14. The prosecution has not found how PW14 came to know of the incident. In this background, if we appreciate the evidence of PW6, we notice that the fact that he is a purely chance witness whose presence at the place of incident is highly doubtful. His conduct too seems to be unnatural in not informing anyone else in the village until he met Khyali Ram. So this may apply to our case because it's very close. She didn't inform the villagers, she didn't inform the police personnel. And this is in addition to the glaring contradiction between her evidence and the evidence of PW5. Those portions of the IO's testimony at page 182, paragraph 20, I had shown where the windshield aspect is also mentioned. After showing PW21 on the last occasion, I had also shown the huge inconsistency between the evidence of PW4, the helper, and PW13, the conductor. And in addition to all this, if my lord sees the SFL report,
yes,
there also I had shown those entries, entry numbers 6 and 9,
correct,
which show that the weapons of offense seized were not having any blood. And there, my lord, no,
and
the
you
Supreme
picked up
Court,
a knife from the spot itself. You said.
yes, no blood is there. What the Supreme Court has held is that if the blood doesn't match the blood group of the deceased, that itself is doubtful. This is a case where there is no blood at all.
Yes, yes.
Then, my lords, most importantly, the IO's evidence where he has said that I got this information of motive from sources. Now, there I had shown 3 judgments, one of my lords from the Delhi High Court, which say that motive, you can't have sources to establish. And motive is an important evidence. I'll give those judgments.
Right.
Once this gets converted into a circumstantial evidence case, motive is highly important. That is not established.
Right.
This is a case, my lords, where by the side of the road, broad daylight, my lords, 2 people have been murdered, 2 young individuals. As per PW 21, my lords, she is someone who was crossing through that road and has seen 6 people assault.
No, from inside a van. She was not herself crossing. She was in the van which was crossing.
From inside a van. Thereafter, my lords, she was taken to the police station where she has recorded her statement. Thereafter, my lords, there has been a TI parade where, my lords, she has identified the 4 witnesses.
Those identification also is in great doubt.
Please, my lords.
Their eyes were not closed and all that.
Eyes were not closed, but
face was all visible to everybody.
Please, my lords.
And then in one shot, everybody is put together. All the accused are put in the same TI parade.
Please,
all this is serious problems you have.
Please, my lords, I'll straight away come to the PM report, my lords, which is...
no, that's a death is homicidal. I don't think you have to labor on that.
Yes, my lords. Yes, my lords. My lords, then the other 2 circumstances is basically the recovery of the gold ring and, my lords, this sword, and the recovery of the apparel. My lords, all this recovery is post, my lords, confession by the accused, and thereafter, my lords, the IO has gone ahead and recovered these things in presence of the accused where they have signed, and those signatures, my lords, are not disputed, that they have signed on those recoveries.
They're not supposed to.
But the witnesses, in fairness, my lords, the witness to the inquest, they have turned hostile. That is, my lords, a case against me. And, my lords, with regard to the IO going ahead with this investigation, it is based on secret information. But, my lords, the qualitative difference being that the secret information is not with regard to whether they were assaulting. The secret information is that they are present in X village from where they were picked up. May I, my lords, show that straight away, my lords. PW 25, page 169, para 3. It is ascertained from my sources that the accused persons are 6 in number within the age group of 20 to 30 who got down from bus near the spot at Ramanabadi Chak, and all of them were wearing full pant and shorts, wearing boots, sandal, etc. Similarly, I got information.
No, that objection is very important.
Please, my lords.
The next 2 lines you just skip.
Yes, my lords. Objected to, but the objection is overruled since the police officer is not bound to disclose his source of information.
Where do you get this law? Where do you get this law?
Millards, and
What is there to connect the accused with the crime?
Millards, the only connection is that
the source, the so-called source. How do which source?
Which is at page 170. The source is not the source.
No, so how does one make the link? Somebody is a police, you're a police officer. Somebody comes and tells you, I know who murdered this person whom you're looking for. He's hiding in that house in the street. You'll simply go and pick up that person.
Millards, not only do I...
Somebody who's a source can tell you so many things.
Please, Millards. But Millards...
How do you satisfy yourself about the link of the person with the crime? How do you satisfy yourself? You just go and pick up.
No, Millards, the recoveries from Millards, that
comes later, sir.
That comes later, Millards. But Millards, the source, Millards, in this particular case, he says that X person is found there, Millards. Not Millards that X person was assaulting the deceased. Millards may kindly appreciate, because the Kanhaiya Mishra judgment, which has been relied upon, Millards, that judgment has been interpreted by Justice Lokur while he was in the Delhi High Court. Millards, may I place that judgment as to how the judgment is?
I'm sorry, Millards, I didn't want to interrupt him. Sources reveal that motive is coming from the sources. Paragraph 3.
Yes, I was
not only
that.
Motive. The question of motive, that there was business rivalry, that is coming from sources. That is what is tainted, Millards.
So I'm coming to that. And Millards, fairly...
So far as location, I bow down. Yes, you can get the location of the accused from sources. But this motive, evidence of motive is coming from sources. And you don't disclose them.
No, but this is a blind case when he starts, correct? Please. He only has 2 dead bodies on the road.
My lord.
How does he satisfy himself about the identity of the persons?
Correct. So what I was trying to say,
the sources have to tell him also about who the person is. It's not that simply telling him the location of the person that he already knows committed the crime.
Millards,
they're also telling him who committed the crime.
Please, Millards.
These sources are everything. Without the source, there's no case. The case doesn't even begin without the source.
That's page 169, Millards. Para 3, where I was reading. 8th line, Millards.
And what is his identity? That everybody was wearing full pant and shirt. Is this a distinct identity for a male?
No, Millards, but...
I mean, what kind? Somebody says, I saw 3 men get down with wearing full pant and shirt, and that is enough to identify a person.
No, Millards, but the apparel that was recovered had blood, Millards.
What else will you recover, sir? You will not be recovering a sari. Please, because what you're supposed to recover is a full pant and shirt. Please, so that means neither here nor there. These are not something so distinct that you can fix the identity of a person. It's so unconvincing. And age group 20 to 30 is a wide description. It can be just about anybody.
Millards, because these persons did not belong to that village.
How do you know that again?
Millards, because
who told you that? Who told you that?
No, Millards. Because that also comes from, Millards, the IO's...
only source.
IO's...
This whole thing. See, this IO has no information. He has not made any investigation. This is the point. Somebody simply comes and tells him 3 people who are in that village are the ones who killed. And he promptly goes there and picks up all the 3 of them.
3 of them are picked up from one place. Yeah, the 4th one is picked up from another
thankfully,
place. Thankfully.
So there are two different
people who are absconding, and the IO has followed.
How does he know? Does he know their names, first of all, to say that they're absconding?
The main person, if my lords may bear with me, during my secret inquiry, it is revealed that there was business rivalry in between deceased E. Krishna Rao Patra with that of one Kishore Prusti, son of late so-and-so of village Asura Bandar, relating to rice.
Is there a single witness who says this? Is there a single witness other than the IO who says this? How can it be so secret that the person cannot come to court and say A has a business rivalry with B?
No, apart from the IO, Millards,
this is not some great defense secret. This is not a case where the security of the nation will get compromised if the witness is examined.
There's only one. There is a co-villager, Millards, the PW 16, Millards, who says that I know accused Ranka Sabat. He's the other accused who's absconding, who belong to my village. The occurrence of this case took place about 4 years back on so and so.
So we are only concerned with the accused who are present in court.
Please.
They are supposed to have business rivalry with the deceased.
Please, my lords.
Tell us one witness who says any one of these accused had a business rivalry with the deceased.
No, my lords, there is nothing on record to show. It is purely based on the IO's.
So how can this be a convincing way of proving a case? The IO will not disclose to anyone, even to the court, the names of such persons. They will not be brought forward. They cannot be confronted. Because they are secret, they can't be confronted.
But in my submission would be that the defense never also put this suggestion.
No, they did. They objected, sir. The objection is overruled.
Yes, my lords.
They got the objection recorded. They got the objection recorded. The entire prosecution case begins with the source. The source fixes the identity of the accused. The source tells the IO where the accused are. The source also gives the motive for the crime. Everything the source. The source is one mysterious source who can't be cross-examined. What if the source also is a business rival who's trying to implicate the accused? Have you ruled that out? So unless there's a cross-examination of the source, how do you rule that out?
Definitely.
I'm finding this very strange. We've come across many cases, not like this. The whole case rests on a source who's mysterious, anonymous.
But these accused have been identified by not one person, but more than the PW21 identifies. And in fact,
that's why that identification becomes so important.
DW1, who was the driver.
If they're shown, that's the whole thing. Are they kept covered? Is the face covered or the face exposed?
The face was exposed.
Then where is the question of identification become? The whole sanctity of identification is over.
Then these are persons with whom the PW21 had not seen ever. So therefore, the face being covered or not covered in my humble submission.
Anyway, if you're satisfied with that submission, it's fine. There's so much case law on this anyway.
Yes, I'm aware of. If apart from the IO's witness, there is nothing which, at least on record, because the other inquest witnesses have turned hostile. So, but the IO has recovered the gold ring, which has been identified by the father of the deceased, which is PW1. And that gold ring had a specific mark, which is written KJ22, and that is conclusive, Millards. And that was something that was worn by the deceased, Millards. Then, Millards, with regard to the murder weapon, the sword, it was put to Millards, the doctor, PW9, and he had said that the injuries might have been caused by the sword that was shown to him. And because of lapse of time, Millards, the blood on the murder weapon, the sample had deteriorated, which is why, Millards, nothing was found. Apart from that, the apparel that was recovered of the accused on their Section 27 statement, Millards, that shows that there were human blood, but the blood group has not been matched, in fairness. And Millards, absence of motive, Millards, the only motive, the link is the source. And apart from that, there is nothing that the IO gets. So as per the case of the prosecution, Millards, the chain, if there is, it gets completed because the recovery of the gold ring and the cash, Millards, because the deceased had gone to the other village to collect some cash, and there are two witnesses whom he had met and had collected cash from them, and they have deposed that one person had given 14,000 odd rupees, the other had given 5,000 that was remaining. So that, Millards, that money, a part of it has been recovered from two accused, Millards. So, and Millards, the gold ring, which, Millards, binds all of them to the
All one gold ring binds all of them.
Yes,
What are you saying, sir?
There's just one person, and because these three were found in the house of Brindavan Sahu, from where Millards the gold ring was found. As with regard to Millards, the lack of independent witnesses to the Caesar Millards Supreme Court judgments, which I'll place it, my lords, it's 2012 for SCC 722. I've given the books.
Give us that. Where is that? 2012?
2012 for SCC 722. Given the list of citations.
Yes. What is this for? What is the proposition?
The proposition is that the lack of independent witnesses to the seizure of a particular material of a particular article will not be fatal to the case.
Isn't this gold ring, you said they're not seized in the first instance, and
yes, gold ring,
it's allowed to remain there for some long number of
the
time.
IO, my lord, says at page 184, that gold ring was kept in an open packet when it was produced before the magistrate PW7. So relevant portion would be page 184. I'm just placing that. I had handed over the seized gold ring to the OIC of Soroda PS on so-and-so. From the time of seizure till so-and-so, it was with me. I have not sealed the ring seized by me after its seizure. It is not a fact that neither the accused Pradeep, while he was in police custody, gave disclosure statement regarding the place of concealment of the said gold ring, nor I recovered from the same so-and-so. I cannot, next line is very important. I cannot say which police officer produced the seized gold ring before the JMFC Surada on the date of TI parade of the seized gold ring. Now, the JMFC says that it was given to me not in an unsealed state, in a plain paper. That, my lord, would find at page 116, paragraph 18.
Yes, I have not specifically mentioned.
Yes. Paragraph 18 of
the suspected ring was kept in a paper cover.
My lords, without being sealed. So who produced the IO's evidence? And so here, my lords, each prosecution witness contradicts each other. And that point I had taken earlier, that some of them have not been declared hostile. That judgment I had shown. Two of them. These persons have not been declared hostile. My lord may see the evidence. There are two such witnesses.
PW13, Swarajya Rao.
Yes. And my lord's PW4. So the prosecution is bound by what they say.
Correct.
And there I had cited that judgment.
Yeah.
So there are so many loopholes. I don't know how would they connect.
Yes.
I can go on and on with them. My lords, PW16 he mentions. PW16 if my lord sees. Let me show that, because since they are relying on PW16.
Yes, PW16 is only...
No, let me show that, because my learned friend from the state may not accept that. Identification for the first time in court is inherently a very weak piece of evidence. That judgment also I'll produce, my lords, right away. My lord may see PW16. Whether this evidence also can be taken into account.
Para 6.
Para 9.
Paragraph 6 and 7. Para 6, my lords, I had not identified the 4 accused persons identified by me today in court in any previous TI parade. Now, 6 has to be read along with paragraph 8 and 9. Para 8, last portion. I was examined by the police on 14/9/2000 near my house. So he was examined by the police after the occurrence, but he is not sent for TI parade. So if at all this case reflects on something, it's a botched up investigation by the IO. If you have found him and he had Yeah, so why wasn't he sent for TI period if I ask myself, my lords? And then the next line, paragraph 9, it is a fact that I did not state before the IO that the 4 accused persons identified by me in court today were seen by me with Ranka at 6 p.m. on 12/9/2000, and the 4 accused persons identified by me today resided in the house of Ranka on the night of 12/9/2000. And 2 judgments regarding this identification for the first time in court. One is 1994 SC. 2 judgments. 1994 SCC Criminal 1751, paragraph 3. Yes. And if my lord would see 1983 SCC, page 411, paragraph 4, my lords.
Volume
1980, volume 3 SCC, page 411, paragraph 4. There were other set of witnesses who failed to identify the respondents at a TI parade and identified them for the first time by face in the court. The High Court has, in a very scientific so-and-so, categorized the identification of witnesses and given cogent reasons for not acting upon the identification of witnesses. Although Mr. Singh argued the case with great vehemence, yet after going through the judgment for so-and-so, we are satisfied that it cannot be said that the circumstances that in view of taken by the High Court are not possible. The relevant portion would be that some of them did not know the accused and identified them in the court for the first time. So both paragraphs, other one also, after arrest, no attempt was made to hold identification parade for PW1 and PW3 to identify the appellant. For the first time, he was identified in the court. So it is difficult to place reliance on such evidence. And if my lord sees PW4 and 5, they have also failed to identify. That's where they should have declared them hostile. That has not happened. PW4, page 109.
PW4
last portion.
Identifies one. PW4 identifies one.
PW4. I was taken inside the jail to identify the culprits arrested in this case, where I had identified one of them. Next line is very important. The witnesses went near the accused persons and replied to have identified none of them. So this, how can they skip this, my lord? After this, I doubt, my lord, how could have they proceeded in this manner?
Yes.
That means the entire thing was, my lord, farcical. And one judgment of the Supreme Court, I need not cite that, where they say that if the case is of this nature, of sensational, the court should be very meticulous. If my lord wants, I'll quickly place that judgment.
Or
no doubt 2 people have died since 94. two people have died, my lords. But the nature of offense is such that the court should be very careful in scrutinizing the evidence.
Right. In fact, the more grave the offense, the more
Yes, my
careful.
lords. It's well accepted, only and just place it for the court's convenience. I'm actually not aware whether this is available with my lords readily. We have got them photocopied.
Can you?
94 supplementary 2 SCC 372. Paragraph 15 is the
Arjun Marikus,
yeah. Paragraph 15, man.
Yeah, correct.
This is the often cited judge. We have given a preliminary note for convenience, which is there in the second appeal. Most of these points we have highlighted.
I'll give my note of submission.
Orders reserved. The counsel for the state is permitted to submit a written note of arguments within a week. All right.
Both appeals, my friend is there in the jail. Both of them are covered.
All right. All right.
Supplementary item number 25.
We are grateful.
May I please?
Yes, please.
In this appeal, the appellant has been convicted under section 302 IPC for life imprisonment and a fine of rupees 10,000 in default to undergo rigorous imprisonment for 6 months by judgment dated 31st August 2006, passed in city case number 3 of 2003 by the Law and Additional Session Judge Talcher. In this case, Your Lordship, the 17 witnesses were examined by the prosecution, and PW1 is the occurrence witness, PW2 is the informant brother who also witnessed the occurrence. Then PW3 is a post-occurrence witness, and PW4 is the wife of the deceased, and PW5 to 8 are hostile witnesses. Then PW9 is the doctor who collected the nail clippings of the accused on police requisition. Then PW10 is the doctor who conducted post-mortem examination over the dead body. Then PW11 is a seizure witness. And then PW12 is another occurrence witness, and so also PW15. The PW13 is a witness to confessional statement and leading to recovery. Then PW14 is a seizure witness, and PW16 and 17 are the police officers who took part in the investigation of the case. Then the judgment is challenged on the ground that there is absence of motive, Your Lordship. The prosecution has failed to prove the motive of the accused to commit the offense. The informant PW2, who is the brother of the deceased, has stated in the cross-examination on page 31 that there is no ill feeling between the family of the accused and our family concerning the landed property. Then PW4, wife of the deceased, also stated so. Then confession of the accused while in police custody leading to recovery of alleged weapon used to killing the deceased is also not free from suspicion, Your Lordship. As per the record, the seizure of the weapon was made on 1st July 2002. But PW1 and PW13 has deposed that the seizure was made on the same day of the occurrence, that is 30th June 2002. Para 8, page 8 of the judgment, Your Lordship. The owner of the house from where the seizure of the weapon has been made was not examined by the prosecution. Hence, the seizure of the weapon is also doubtful. Then the evidence of PW1, who is stated to be the only eyewitness to the occurrence, is not free from doubt. There was previous enmity between PW1 and the appellant, for which a criminal case was also instituted. Then scribe of the affair. Then scribe of the affair is also doubt. That PW2, the informant, has deposed that the SI of the police station has scribed the affair. But PW1 has scribed the affair but did not give his endorsement thereon. This shows that PW1 is the interested witness and falsely implicated the appellant. Then the place of lying of the dead body and the spot of occurrence were not specified. That is para 10 of the judgment. According to PW2, it was near Mangala Koti. According to PW1, it was Bijestali of Mangala Thakurani. According to PW3, it was Bounsapalla Sahi. And according to PW12, at Rengalishwara Sahi in front of his cabin. So the accused has already spent 16 years inside the custody.
All right. How many injuries on the person?
Left side.
Can you tell us the doctor's evidence, the doctor who conducted the autopsy?
Yes, yes.
He's PW who? What?
Doctor is PW 10. PW 10 is the doctor.
Just read it.
Page 41.
Single injury. Not even repeat stab. Anything to say on this?
No.
No. All right. Yes, Mr. Katkia, let's start with the doctor's evidence.
Dr. PW 10 loss. There is one puncture wound. Elliptical in size into 6 inch on 1 inch lateral to sternum of right side chest cavity. Has been filled with blood, pericardium congested and full of blood. So there is one wound, puncture wound, just in the chest.
Yes. So what's the law on that?
Law on that means even if there is one injury, but still it cannot be converted to section 304 part 1.
Let's see what the law is.
There is
There have been so many cases of conversion because of even a single wound on the chest.
That depends on the facts and circumstances of the case.
Correct.
From case to case it varies.
Correct.
And that you'll also get it from 2020 volume 9 SCC, page 5 to 4.
Let's see that.
I have not brought the judge. Only sir. I'll supply it. 2020 volume 9 SCC, page 524, Stalin versus State.
There is a judgment from the state of Punjab. I forget I think it's a 1980 Supreme Court from Punjab where a single stab wound was converted.
Other judgments also. That accused cannot.
He's already spent 16 years in jail. He's already spent 16 years in jail.
I leave to Oscar.
You give us some case law on that.
I'll give. I'll provide.
Orders reserved.
And there are 3 eyewitnesses, direct eyewitnesses are there.
One. Actually, the second one.
1, 2, and 12.
But motive is not proved.
No, so that is in the FIR that is there. There is a quarrel. The prior to that, there is a quarrel. So I am just bringing lots to notice.
But none of the witness talk of quarrel.
But motive in one,
but in this kind of a case, there was a single wound and none of the witness talks of a quarrel.
But FIR has been exhibited. Of course, I can say it's clear that FIR is not an encyclopedia of everything. But there has been reflected in the FIR that prior to few days prior to that, there is a quarrel between
the accused. None of the witnesses speak.
Yes, I will examine and I will file a small note.
Orders reserved. I think it's stopping. Oh, we just give dates to the other. Oh, all right. Weekly listing will be as yeah.
Supplementary list item 26.
26. Plus, in this case, in one appeal, I was appearing. So I humbly pray, maybe I don't know, some of us, my friend Mr. Moduli Lagu is Mr.
I see.
Because the file has come to me.
And I pray in the meantime, paper book may be provided to us.
Macaulay directed. All right. Paper books we provided to counsel for the appellants. stated that Mr. Mudali will be appearing for the state.
That in
List on 8th September.
Item 27.
Pardon, my lord. In item 26, there are 3 appellants, your lordship. Out of 3, 2 appellants were on bail, your lordship. I am for the appellant number 1, Yakub Asim. He is in custody last 13 years.
You argue today, sir. We are prepared to hear you today.
My lord, I have that much of document to argue only for bail, your lordship, for not criminal appeal, because your lordship, evidence of PW11.
We are not now considering bail, sir. We are now hearing the appeal.
Next date, your lordship. Yeah. On next date.
Item 27.
And in this case, I am appearing on for the appellant, and shortly it is file my memo.
The thing is,
I want some time for a better paper.
All right, same date, 8th September. At the request of counsel, the appellant, 8th September.
Item 28.
no, the noting is appearance, SR appearance notice issued to appellant not returned.
Which one is that?
Item 28.
Because also has directed for the last occasion. The appellant to appear.
What is your information?
The registry notice has gone.
Were you IAC not asked to make an inquiry? The notice
No, I can intimate the
returned.
Pardon, my lord. I for 28, my lord. So I pay for times which
Have you
time.
contacted the appellant?
Pardon, my lord. Oh, for appearance of the appellant. That is
no.
27. 27, sir.
28, sir.
28.
Have you contacted the appellant? Have you been in touch with the appellant?
28.
28.
I pray for times, my lord. 28.
Have you contacted the appellant in the meantime?
I have not contacted through the legal aid sites. I got the brief.
Did you see the order?
Yes, yes. That is
What does the order say? Read para 3.
my lord. Para 1, non-appearance for the appellant.
Sir, para 3.
Last line. Para 3, my lord.
Last line of para 3.
Para 3. The panel council will get in touch with the appellant for instruction.
What did you do? When did you get the brief?
That's why. Yes, my lord, that is, I could not contact her.
This SHO was supposed to serve. What happened?
Yes,
Notice was supposed to be served through SHO.
Notice that SR is not back.
SHO he takes means not bailiff, sir.
I will obtain instruction from the SHO.
The appellant continues not to appear. The SHO was asked to serve notice upon him for his appearance. There is no report of the SHO. Matters adjourned to 8 September. The SHO will ensure the service of notice on the appellant for his appearance in the court on the next date. This notice be issued to the SHO without process fee. Put down the name of that counsel.
All right. Item 29. Item number 29.
Please, there is a direction in order number 3 that the appellant to be remain present on the next date. That is today, Mala. And a direction to me that take the instruction touch with the applicant. I have obtained the telephone number from the website of the Bhavani Vatna jail, Mala. But the number was does not exist, Mala.
Where is the appellant?
I will ensure.
Same order in this also. Same order.
Supplementary list item number 30.
I am for appellant number 10, my lord. Yeah, there are other sets of advocates also.
I am appellant number 6, my lord. I take some time.
Yes, sir.
My lord, I am appellant number 10. There are other sets of advocates also. My grandfriend wants time. I
He
press
can
for
say for
bail.
himself, sir. Why do you want to ask me for help?
I press for bail because
We are not going to do that. We have listed it for hearing. We want you to argue the appeal. Simple.
that mechanism, short adjournment mechanism.
So the more you keep taking time, the more your client is going to be in jail.
He is inside jail for last 11 years. Man.
So every time you ask for adjournment, that 11 years will become 11 years and 1 month, 11 years and 2 months, 11 years and 3 months. So how are you helping your client? Every time you come, ask for adjournment.
No, man. Whatever,
And then you keep saying he's for 11 years in jail. How are you helping him, sir?
So far as my case, my client is concerned, there is no, he is in head of 149 only. There is no overact done by him, as revealed from the record. So others will argue the case and lastly I will argue. Because all are
So who's appearing for whom now?
In one appeal.
Who's appearing for whom? This P. Nokia and others you have to say. Yes.
There are 18 appellants.
One appellant.
18.
18 appellants in one appellant.
Cancel the bail, I think, for all of them. Everybody will come rushing. How many people are on bail?
70.
I think if lawyers fail to appear, we'll just cancel the bail. This is another tactic. Otherwise, they never come up. Who's appearing in this for appellant number 1, 455? Appeal 455, 2012. Who's for appellant number 1?
So appellant 2 has been released on bail by order dated 28th June 2016.
The last occasion. Which is the date?
Plus 28th June 2016. 2016.
No, appellant number 1 is still in jail.
Appellant 2 plus.
No, appellant number 1 is still in jail.
Most of the appellants are in jail. Appellant 1 is jail.
What's in jail?
Most likely, I have to verify from the record itself. Because most of the times they have moved the bail applications.
You are appearing for, sir?
I am for appellant number 10.
10. Ganapati.
Ganapati.
And you are for?
I am appellant number 6. P.
6.
Madhav Rao.
P. Madhav Rao. He's on bail.
No, man.
Who's on bail, sir? Except appellant number 2 or none else is in bail, is it? I love the prayer for bail of appellants 4, 5, 7, 8, 9, 11, 12, 13, 14, 16, 17.
Appellant number 2, religion bail, my lord, 28/6/2016.
That's right. 28/9/2012 itself. So,
and also appellant number 18 also religion bail, my lord. That is on dated 1/3/2016.
So we'll cancel, sir. All the bails should be cancelled.
That is game chance, one chance, my lord, next week, one chance. Last chance.
'18 was released on bail on 1/3/2016. Two was released on 28/6.
In the year 2012, on 28 September 2012, also can peru that order. Maybe 28/9/2012.
Yeah. Many people have got out. We've seen that only. You see, there are 18 accused in the appellants, accused, of which barring appellant numbers 1, 3, 6, 10, and 15, all the others are on bail. Paragraph today, when the appeal is called out, only counsel for appellant numbers
10.
6 and 10 are present. Stop.
For the appellant of 3, I have not gone on bail.
Sir, we're not able to hear you, sir. You have to speak in the mic.
My lord, I am appearing for the appellant of 3. I have not gone bail. I
have not said you have got bail. You said, what have I said? Today, when the matter is called out, only counsel for appellants 3, 6, and 10 are present. Counsel for the other appellants are not present. Counsel who are present are not prepared to argue the appeal. Paragraph. With at least 5 of the appellants being in jail, the court is unable to comprehend the reluctance of counsel to either appear or argue the matters. Stop. Notice without process fee be issued to the concerned IIC to each of the appellants who are on bail. That is appellants numbers 4, 5, 7, 8, 9, 11, 12, 13, 14, 16, 17, 18. We start with 2. To personally remain present in the court on the next day to explain why their bails will not be cancelled. Full stop. It is made clear that if the counsel appearing for them are not present on the next date, the court will be constrained to proceed with the matter by engaging for them counsel from the High Court panel of the High Court Legal Services Committee. List on 15 September.
For a free copy, Sorry, copy of the order may be given.
Yes, yes, urgent copy.
Item 31.
I am for the appellant number 1, my lord.
My lord, I am for the appellant number 2. And within Kumar Das.
So we'll take it up next Thursday, sir. List on 29th July. 28 July. This one is
Item 32.
My lord, we are praying for time. If your lordship will grant us few days time, we will file the death chart and some judgment.
What's the matter about, sir? Tell us.
My lord, in this case, we are challenging the legality of the pay scale prescribed by the personal assistant, my lord.
So revision of pay scale is what? So pay commission's task, I suppose. The High Court. This is the Sessions Court.
Yes, my lord.
Pay scale of which post is this? Personal assistant.
Yes, my lord. PA.
How can it be separately considered? I don't know.
First prayer is to declare them as gazetted officers. Then
At the
second,
request of counsel, the petitioners list on 23rd November.
Deeply obliged.
Supplementary list item 33.
Obliged.
Lord, the question is whether the fact and the circumstances of the case and in law, the learned tribunal is justified in deleting the penalty under section 271(1)(c) of the act passed by the AO on 12/3/2014 pertaining to the assessment of
This
2006.
can come with a regular course, I think. You say list in due course. That's it. What's the hurry, sir? List in due course.